Good afternoon, everybody. The Appellate Division First Department is now in session for our Thursday, February 24th, 2022 virtual session. I think we start with live sessions again next week, so that'll be very exciting. Hopefully we won't have to go back to virtual, maybe ever. But nice to see everybody, and I am going to call the calendar. You've already been assigned time, so you don't have to answer. The clerk has already gone through the calendar. Unless you're on cases 3 and 4, then you can let me know that you've shown up since Ms. Soa called the calendar. Okay. The first case is People versus Gaddiel Padilla. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Kade versus Schwartz. The appellant has 3 minutes and the respondent is submitting. The third case, C. Evangelista versus Maxine K. I understand that neither of the attorneys are here, so we are going to mark the case submitted. Similarly, American Transit versus Alcantara. I understand no one's here, so that case will also be marked submitted. People versus Lawrence Harvey. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Rivera versus Lopez Reyes. The appellant has 5 minutes and 1 for rebuttal. The respondent has 5 minutes. Charrington versus New York City Transit Authority. The appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Waldron versus City of New York. Excuse me. The appellant has 5 minutes and 2 for rebuttal. The respondent, City of New York, has 4 minutes, and the respondent, Eaton Electric, has 4 minutes. People versus Robert Stover, that case is submitted. Merchants Mutual versus Dunham Piping, the appellant has 5 minutes and 2 for rebuttal. The respondent has 5 minutes. Handelsman versus Llewellyn, the appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. State Farm Mutual versus Global Supply, the appellant has 4 minutes. The respondent is submitting. Perez versus Long Island Concrete. The appellant, Long Island Concrete, has 5 minutes and 1 for rebuttal. The appellant, Regulator Construction, has 4 minutes and 1 for rebuttal. And the respondent has 6 minutes. People versus Ash. The appellant has 6 minutes and 2 for rebuttal. The respondent has 6 minutes. Robinson versus Deneen is submitted, and D'Souza versus Manhattan RX is also submitted. So I just remind you, as I'm sure most of you well know by now, please keep your computers muted until your case is actually called to avoid background noises as much as possible. Please try to avoid talking over the judges. I know you would always try to do that, but be especially careful on the computer. And I will be keeping the time. If we still have questions, we'll continue on. Otherwise, you can keep an eye on the time, and so will I. So this has worked well so far. No reason that it won't this afternoon. So the first case for oral argument is People versus Padilla. The appellant, you have 5 minutes. Ms. Watrous?
Yes.
Good afternoon.
Good afternoon, and may it please the court, Shana Watrous on behalf of Gaddiel Padilla. The trial court was wrong to deny suppression of the gun, which was discovered in the course of an illegal search. The officer was incredible as a matter of law, where he clearly changed his story over time to nullify constitutional objections. So we have 3 sort of separate stories.
There's varying versions. I presume you're reflecting the point that he says that he saw the outline of a gun in the defendant's pocket, which he hadn't seen early, which he hadn't stated on other occasions. But what is really a conflict between what he said on earlier versions and what he testifies to about seeing the outline of a gun? There's not really a conflict, is there?
There is a conflict. Sorry, did you finish your question?
Go ahead.
There is a conflict. It's not just that he said he saw an outline at one point and other times he didn't. It's that the first time he told the story, which was just hours after the arrest, he said that Mr. Padilla's hand was actually covering whatever was in his pocket. So there was no way for him to have seen what he said was the outline, not just of a gun, but of the sort of long barrel of a gun.
But
There was no way.
Doesn't he say, what is it, that his left hand is on his knee? The defendant has his left hand on his knee as he's sitting in the stairway, and the right hand was by his side. Isn't that what he says?
He first says that the hand is covering the bulge, and then weeks later at the grand jury testimony that he gave, he then said that the hand was by his side, so he was able to see the outline of the barrel of the gun. There's no way that it was accurate that his hand was covering the bulge, and then later his hand wasn't covering.
So he actually said that his hand was covering the bulge?
Yes, Your Honor.
Well, then he saw the bulge.
Right, but just seeing a bulge doesn't give him reasonable suspicion to search. There has to be a bulge in the shape of something, that would tend to show some kind of criminality. He could have had his hand over a cell phone. He could have had his hand over a wallet, but the courts have made clear that you need to see the outline of a gun.
Doesn't he see the outline of a handle through the Yankee jersey that the defendant is wearing, covering
No, Your Honor.
his pants?
He doesn't see the outline of a handle. He only ever says later, several years later at the hearing, when he does describe seeing what he actually saw an outline of, he only says that he sees the barrel of a gun, which was not covered by Mr. Padilla's hand, which is directly in contradiction with what he said when the incident was fresh in his mind right after the arrest when he was talking to the ADA. So it's very troubling that it does seem like someone, he changed his story in order to nullify these constitutional objections. And I do want to turn to just the Padilla issue quickly, that Mr. Padilla was not, or I'm sorry, to the Peke issue. Yes, Mr. Padilla was not told that there could be any kind of...
Is there an issue as to the applicability of PECA since his plea was taken 3.5 years before PECA was decided?
New York courts have been very clear that it is retroactive as long as there hasn't been any kind of finality in the case, and there was not in this case. The appeal had not been completed, that PECA does apply retroactively. And PECA says that the court must give some kind of a warning about potential immigration consequences. And here, immigration wasn't even discussed at all during.
What does the defendant say about his immigration status? He makes some concession, does he not, actually, in his 440 motion? He's aware of his immigration issue. He recognizes that, doesn't he?
Whatever he knows about the potential immigration issue, it doesn't relieve the court of its duty under PECA to give him some kind of a warning.
Well, why would the court warn someone who represents to the court that they were born in Puerto Rico? If you're born in Puerto Rico, you're an American citizen.
Right, and it would be a different situation if he had represented to the court that he was born in Puerto Rico, but he made no such representation. That was not before the court.
What do you mean?
The court had no
such representation. The pre-sentence report says he was born in Puerto Rico. On his fingerprints, he represented that his arraignment fingerprint sheet. He represented he was born in Puerto Rico. That's what he gave for his place of birth on 3 separate documents.
So the plea is taken prior to the pre-sentence report, so the court has no indication that he is a non-citizen.
First of all, that's there's a discussion that can be had about that. But there are 2 documents that the court has when it takes the plea, both of which include a representation by the defendant that he was born in Puerto Rico.
And I'm sorry.
Counsel, this is Judge Owen. He also, when the court asked him under oath if he was Mr. Padilla, he answered affirmatively that he was. So at that point, right there, if he's not Mr. Padilla, then he's just committed a fraud upon the court.
But there's nothing in what he said that is.
No, counsel, he acknowledged when the court said, "Are you Mr. Padilla?" And he acknowledged after being sworn, "Yes, I am." That's an affirmative acknowledgement that he is Padilla. So at that point, when you have all the documents that show he's born in Puerto Rico, that Abe Padilla is born in Puerto Rico, he's a U.S. citizen.
The only document prior to the plea that indicated that he was born in Puerto Rico was a notation on a police arrest record that was not, it was not in front of the court at the time. It had been brought up at one.
All the paperwork on this shows that he's a U.S. citizen because the defendant's arrest report says that he's a U.S. citizen. The defendant's fingerprint response summary reflects that he's a citizen, that was born in Puerto Rico. So all of the paperwork on this shows him to be an American citizen.
Your Honor, I'm not aware of any case where a judge was allowed to not, go forward with the Peque warnings, except when the court says, "Are you a U.S. citizen?" and he responds that he is a U.S. citizen. That then allows him to not hear those warnings. But otherwise, the court had no way of knowing that he didn't.
Are you suggesting then that the court is required now for every defendant that comes before them to ask them what their immigration status is?
When
that's what it sounds like you're suggesting. There is it's a bright line, black and white. Every defendant should be asked their immigration consequences. That's what you seem to be suggesting.
I'm sorry if it seems like I'm suggesting that. It's just what New York courts have said, that there must be some kind of a warning, unless it's.
I'm sorry, I interrupted you. Go ahead.
I was just going to say that there needs to be some kind of a warning, unless the person has affirmatively misrepresented their status to the court. And here, the fact that he might have, in his fear at the time of being arrested, said that he was a U.S. citizen, said that he was a Puerto Rican, does not mean that this court had that affirmatively misrepresented to him.
I'm confused. So if a defendant puts down that they were born in Massachusetts, or at the place of birth, Massachusetts, the court has to say to that defendant, "Are you a United States citizen?"
No, Your Honor, but in this case, Mr. Padilla.
Why? But you just said that the court has to inquire. Why don't you have to inquire if the person puts down Massachusetts?
There was nothing in front of this plea judge that would indicate that he was born anywhere. The arrest
obviously
report,
born somewhere. We know that.
Correct. Yes, Your Honor. There was nothing.
Counsel, my problem is getting over the fact that he acknowledged who he was in front of the judge. He gave the judge under oath, he's sworn, that he acknowledged that he was Gaddiel Padilla. Right then and there, that's what I'm trying to get over the hurdle, because you're making all these arguments on the assumption that he's not Gaddiel Padilla, but he acknowledged he was. All your arguments will carry more weight with me if he never acknowledged to the court that he was Gaddiel Padilla, because somewhere in the record he's acknowledged that his name was something else, that his real name is something else.
So I just want to say that there's no case law that says that if you just affirm that you have a particular name, that you are a U.S. citizen. But I do want to quickly, before my time is up, just turn to the.
Your time is way up, but you have.
Okay. All right. I want to cover the excessive sentence issue, but I can do that on rebuttal. Thank you.
Why don't you do? Thank you very much. We'll hear from Ms. Yancey now. Thank you.
Good afternoon, Felicia Yancey for the people. I just wanted to reiterate that in this case, even if you don't want to accept that that was an affirmative acknowledgement that he under oath to the court is Gaddiel Padilla, therefore a United States citizen. It also, there's another issue that came out in the Parker hearing in which it was learned, as they found out his real name was Neri Ortiz, that there was in fact a real live person called Gaddiel Padilla who had died in 2003, which had the same date of birth, and that this defendant was arrested in 2008 for a forged instrument, and that being a false driver's license in the name of Gaddiel Padilla. So this had been something that he had been perpetrating for actually quite a while. And when he was asked in there, again, as Judge Fabrizio stated, all of the official documents in the court file, that being his criminal history, as well as even the arrest complaint report, indicated that Gaddiel Padilla did in fact live in Puerto Rico and was a United States citizen. And by the court asking the defendant if indeed he is Gaddiel Padilla, which the court believes was a U.S. citizen, that he affirmatively misrepresented to the court under oath that he in fact was Gaddiel Padilla, U.S. Citizen. So, and according to Brazil, that is the People v. Brazil, that is the one of those instances where the deportation or immigration inquiry is not required. And
in any event, should the defendant have moved at the time of sentence to withdraw his plea if he wanted to assert that he is denied this right?
that possibly could have been something that he could have done, but he did not do so. And as far as the excessive sentence is concerned, he was clearly warned that there were 3 factors he could not actually do, and that was not come to court and not be uncooperative to probation, as well as get rearrested. And he simply did not come to court and the on sentencing day, and the court was very specific about it. So the enhanced sentence that he was promised was not excessive, and the people actually conceded that the post-release supervision of 5 years was not permitted, and we conceded that should be to 3 years. So for all those reasons, we ask that the court affirm the judgment in all respects.
Okay, thank you very much, Ms. Yancey. Ms. Watrous, you have 2 minutes.
Thank you. Mr. Padilla was a 25-year-old man who pleaded to 2 years, pleaded guilty in exchange for a promise of 2 years. Of course, there needed to be some kind of repercussion. He had been warned that if he didn't come back to court, that he would get some kind of an enhanced sentence, that he could get up to 7 years. But I will just note that it is remarkable that this man who held down a steady job prior to this, he got more than 3 years, than 3 times the original.
Ms. Watrous, this is Judge Gassmer. I agree that 7 years is a much larger number. On the other hand, he had also absconded for 7 years. Don't you think some substantial, one can imagine if he'd missed a court date and turned himself in and showed up a few weeks later that 7 years might have seemed excessive. But when he absented himself for 7 years, doesn't that make it more difficult to argue that that's excessive?
This court has found that when someone has absented themselves for many years, at least this amount, that there can still be a reduction from the maximum. And I would just note that he got more than 3 times the sentence that he originally pled to. It would be understandable if he, got double the sentence that he had pled to, but more than 3 times his original promised sentence just was excessive in this case, where he had a steady job, had a child, would just note that during the time that he was not, that he had absented himself, that he did not get rearrested on anything. He was just picked up when he went to go visit family out of the country for a few weeks. And he's someone who doesn't, it's not necessary to hold him in for 7 years on a case like this. So we would just say that for a young man that's 25 years old at the time of this arrest, that it was a really harsh sentence and it should be reduced. It would make sense, I think, to double the sentence that he had been promised, to make it 4 years.
Counsel, this is Judge Owing. This was a gun charge, right? He pleaded guilty to possessing a weapon, and in my understanding, it was pretty large. It was a pretty large weapon. All right.
We don't know the size of the weapon, but certainly
I saw the record. It wasn't a toy pistol. Okay, I got it. Thank you. And
I would just add one more thing, which is that he was very open and honest. As soon as he was arrested, he admitted to everything that he did. He took full responsibility for this case. And I would just ask that his sentence be reduced in the interest of justice. Thank you.
Okay, thank you. Thank you both very much. The next case for oral argument is Kade versus Schwartz, and we have just the appellant. We've given you 3 minutes. Anything you'd like to bring to our attention, of course.
Good afternoon. May it please the court. My name is Elizabeth Adenolfi. I am counsel for the appellants, Linda Ayers and John Schwartz, as the executors of the estate of Joan Schwartz. I appreciate the court giving me this time this afternoon. I really wanted to have the opportunity to speak with the court to emphasize that there is a real significant public policy issue here. There is such an emphasis on trying to keep the elderly in their homes, in the community, to avoid having to institutionalize, place people in nursing homes.
But counsel, this is Justice Gasmer. Isn't the question before us really just whether or not plaintiff stated a cause of action for which we really don't have to, that's a pure question of law for which we really don't have to reach a policy issue, isn't it?
Well, I was addressing the issue of whether or not the defensive assumption of risk would apply to a situation like this if the court did find
Where
that she
was that raised in your motion?
We raised it at oral argument.
No, in your motion papers, where was that raised?
It was not raised in the motion papers, Your Honor.
Thank you.
But as we've put in our brief, that this is a question of law, and the fact that it was not raised on motion but was raised at oral argument does not prohibit the court from considering it on appeal.
Well, as we've been instructed several times by the Court of Appeals, we are not a policy court. We are a court of law and facts. So I would emphasize Justice Gesman's question as to be the one that you might want to focus on.
Well, but I think, Your Honor, courts in New York, at least the Nassau County Court, subsequent to our case being decided by Justice Kotler, has adopted the assumption of risk in looking at situations where a caregiver is injured, although in this case,
well, Justice Gesman's question was whether or not the plaintiff made out the cause of action in her pleadings. I think that was what Justice Gesman was asking.
Well, I don't believe that she did. Justice Kotler disagreed. I do think the scenario, as vaguely as it was described, of swinging a cane in someone's direction was not.
How did it come to be a third amended complaint here?
There was also a fifth amended complaint, Your Honor. Ms. Kade just repeatedly kept submitting additional amended complaints. Our motion to dismiss was actually geared
at the second.
So
you mean after the third amended complaint has been a fifth amended complaint?
I believe we got it to a fifth amended complaint.
Was that as of right or was permission granted?
Neither. She just kept submitting amended complaints, Your Honor. It just would not end. And
did you object in your appeal to us to the trial court's consideration of the third amended complaint instead of the second amended complaint?
We did not, because the legal issues were not significantly different, and Justice Kotler believed that it was applicable to looking at the question of whether leave to replead should be granted, and in making her decision, whether it was the second or the third amended complaint, I don't think made a significant difference, but I do think it factored into her decision not to permit leave to replead on the other issues. But to the extent that the causes of action were dismissed, there's no appeal from the decision dismissing those previous causes of action or denial of the leave to replead.
Ms. Kade had originally had appealed, but she withdrew her appeal. Is that what happened?
I believe she withdrew her appeal against Alliance and has filed against them in federal court. And she did withdraw her appeal against the estate. I think she then tried to reinstate it, and this court denied her permission to reinstate her appeal.
And her brief in this case also addresses her appeal. It's not just a respondent's brief, it's also an appellant's brief, even though she doesn't have an appeal.
Well, Your Honor, as a pro se litigant, I do understand that the courts do extend a certain amount of patience and tolerance, but Ms. Kade, I believe, has pushed every court past that level. She withdrew the appeal. She tried to reinstate it. Even when that was denied, she still tried to present the court with an appellate brief. We asked the court to disregard all of that simply because those issues are not before the court at this point.
Does the record reflect whether she is licensed in any way?
I believe she's a certified, I believe she's a CNA. I believe that was in one of the complaints. I don't recall which one, but she
Because I know your brief says that she's highly skilled, some such language. So
she represents herself as an experienced home care professional. Those are her words. That's her description of herself. And this is a case, we're not talking about where a client, picked up a cane and started, beating her with it. This wasn't really a violent encounter.
She was out within an hour or two of having arrived.
I believe it was less than 3 hours, Your Honor. I don't remember the exact time, but it didn't make it through, the first half of her shift. And we've now been litigating for 3 years, and I believe her last request was for over $5 million in damages for, what was understandably an upsetting encounter with a rude, elderly, woman who didn't like that she had to have aides in her home. But that's not uncommon. And it certainly doesn't give rise to millions of dollars in damages.
Okay. Do we have any further questions for Ms. Adinolfi? Okay, thank you very much. We appreciate your time this afternoon.
Thank you, Your Honor. I appreciate the opportunity.
Have a great afternoon. The next case for oral argument is People versus Harvey. Mr. Wu, correct?
Yes, Your Honor.
Hi, good afternoon.
Hi, good afternoon, Your Honors. Victoria Wu, Office of the Appellate Defender for Mr. Harvey. I would like to address 2 issues today. First, the trial court's decision to exclude the complainant's prior statement that she had done more physically to Mr. Harvey than he had to her. And second, the trial court's failure to remain impartial. First, the complainant's prior statement that between April 25 and October 19, she had done more physically to Mr. Harvey than he had to her was critical because it contradicted the complainant's allegation and would have cast the entire case under a different light. Indeed, that statement in and of itself suggested that the purported assault did not happen. The court below recognized as much.
Oh, wait a minute, counsel. When you say the purported assault didn't happen, there's photographic evidence of this assault, right?
With respect to the photos, it's important to note that they were not dated. And so the statement from the complainant that she had done more stuff physically to Mr. Harvey certainly would have led the jury to question the specific circumstances under which those photos were taken.
But whether or not they were dated, if they were identified properly and admitted into evidence, they don't have to have been dated at the time. They just have to have been identified at trial, right?
Yeah, it's not an issue in terms of authenticity. The issue is that the defense theory in this case was that the complainant had fabricated the allegation. And obviously her prior statement that she had done more stuff physically to Mr. Harvey than he had to her supported that defense theory. And the jury was therefore would have been led to, question what the photos exactly showed, the circumstances under which they were taken. And because this prior statement would have cast all of the prosecution's evidence in a different light, it was imperative for defense counsel to have been able to put this statement to the jury so that the jury can consider it and hear it and weigh it in light of all the evidence in this case. In this case, the court below acknowledged that this statement would have been very damaging to the prosecution's case. Indeed, in precluding the statement from coming in, the court criticized defense counsel for, quote, making the whole thing sound like it would be some fabrication. This remark was glaring not only because it demonstrated the court's bias toward the prosecution, but also because it prevented defense counsel from presenting a critical piece of evidence in support of the defense theory, which was that the allegation was fabricated. Importantly, the prosecution in summation acknowledged that, quote, this case comes down to, do you believe the complainant or do you not believe the complainant? In these circumstances, the jury should have been able to hear the complainant's own admission in a recording that she made that during the time period in question, she had done more physically to Mr. Harvey than he had to her.
Wasn't that statement that you wanted to have entered sort of taken out of context in the course of a lot of conversations that were available?
So that was not the basis for the trial court's decision. The prosecutor did suggest that, additional portions of the recording should be admitted. And in response to that, defense counsel agreed. He said, I'm willing to let the rest of the recording come in. At that point, the prosecution then changed its tune and said, this is not relevant. And the court excluded the statement for reasons not related to it being out of context, given that defense counsel had at that point agreed to put in the rest of the recording. So again, this piece of evidence was critical to the defense theory. It went to the core of the case, and its exclusion was both erroneous and prejudicial. Apart from this evidentiary ruling, the record shows that the trial court violated the fundamental principle that a judge must not only be neutral, but appear so as well. The court's criticism that defense counsel was, quote, making the whole thing sound like it would be some fabrication was a prime example of the court's bias, and unfortunately, it was not the only instance of such conduct. When the defense counsel tried to challenge the complainant's testimony that Mr. Harvey and the complainant's sister came back to the apartment on April 30th together, as opposed to separately, the court stopped the questioning, stating, quote, she doesn't remember this, but she remembers somebody shoving up things. This remark was beyond the pale and injudicious. The court also stopped the questioning on the ground that, quote, the crime was May 22nd, and, quote, if you want to have what happened close to that, that's fine. But as a result of its Molina ruling, the court allowed the prosecution to explore events that were far more distant in time. The double standard the court below used could not be more obvious. The record contains other examples of the court's bias. When defense counsel tried to cross-examine the complainant about a prior statement that undermined her claim that the playroom in the apartment had a door on May 22nd, the court precluded the questioning, stating, quote, this is what she remembers about the door. I will not allow it. And again, when defense counsel tried to cross-examine the complainant about whether she used a laptop to search certain songs, the court precluded the questioning, repeatedly saying, quote, she said she didn't have access. The record makes plain that the trial court...
Well, hold on a minute. Does anybody have any particular questions that we want to ask Mr. Wu? All right, you'll have a few minutes on rebuttal, Mr. Wu. I've given you a little extra time. Let's hear from the prosecution, and then we'll be happy to listen to you. Ms. Campbell-Urban?
Good afternoon, Jeannie Campbell-Urban for the people. Can you hear me okay, Your Honor?
Yes, you're fine. Thank you.
Great. I feel that there is a lot to respond to. I think I'll first quickly address the issue of judicial bias and then address the specific issue that my adversary has with the October 19th recording. It is simply not the case, if you look at the totality of this trial record, that the defendant received an unfair trial or that the judge was biased against him. The judge made hundreds of evidentiary rulings in this case, which was a weeks-long trial. Many of them were favorable to the defendant, and all of them were fair. The defense is simply taking snippets of the judge's comments out of context and holding them up as an example of bias when none actually existed.
So let's
With
turn
respect
your
to-
attention. Let's turn your attention to the statement, which was stopped on cross-examination, in which the victim says, you know, physically, she seems to concede that physically she's done more to him than he's done to her, and the court doesn't precludes cross-examination on that. I mean, because it's out of context. But when you have that sort of an issue, isn't the way to handle it that you allow the cross-examination and then you give the people an opportunity to show the context? I mean, how do you
Your Honor,
justify?
I'm sorry.
No, go ahead.
Your Honor, I think the manner of dealing with this area that you just suggested is one of the numerous reasonable ways to deal with it. Again, we're dealing with the court's discretionary determinations, and there is a range of reasonable options for dealing with this particular statement. I want to contextualize this ruling by saying that this occurred on the third day of cross-examination. The defense had already cross-examined the victim using numerous snippets of prior recordings that she had made of the defendant's conversations. And the fact that it was really the defendant's comment with which the victim then agreed influenced the judge's decision not to allow the jury to hear it. I just want to be clear on what the play-by-play was. The defendant said, of all the physical acts that have happened since April 25th between you and me, you know you've done more to me than I've done to you. That's the defendant, okay? The victim, who testified ad nauseum that she yesed him and tried to placate him frequently in their relationship, responded, on the physical, maybe this is that and maybe you're right, but emotionally and verbally you've done more to me. That statement, my position is that statement in and of itself is ambiguous. Even if you adopt the defense claim that she is agreeing that she has been physically abusive to the defendant, which I don't think the record supports, there were portions of the rest of the recording where she says the exact opposite, where she accuses the defendant of relentless physical abuse and threats. The people raised the concern that the defense
that's the very point that, you know, then the people bring that out when they have redirect.
I do think that that's what the court was initially leaning towards, Your Honor, but then was reminded by the people that the transcript of this recorded conversation was 160 pages long, and it was a 3-hour-long conversation filled with irrelevant details. She then asked to see a transcript of the specific exchange at issue, at which point, after reading it line for line, concluded that the exchange was too nebulous, and also that because it required bringing out the defendant's self-serving statement, it was a violation of the rules of evidence. That was a reasonable, fair ruling, especially in the context of this being the third day of cross-examination. The defense relentlessly cross-examined the victim about all number of topics and was singularly focused on painting her as a liar before the jury. This one isolated comment by the defendant and then by the victim would, if they had been permitted to cross-examine her on it, it would not have changed the result of this case, not only because of the fact that he had ample opportunity to cross-examine the victim, but because, as Justice Gesmer alluded to earlier on, the evidence of the defendant's guilt was overwhelming. The photographs that my adversary says were undated showed the victim half naked, bound in tape at the wrists and ankles, hogtied with a white rope and tape encircling her mouth and a dress tie covering it. There was also a belt under her neck. One of the defendant's shoes was caught in one of those photographs because he accidentally stepped into the frame when he was photographing her from above. And the photos is just the beginning of the corroboration of the victim's narrative. She called 911 twice and hung up that night. There was DNA evidence that supported her narrative of what occurred. There was the defendant's admissions after the fact, where he referred to that fateful that horrible Saturday. The assault had occurred the Saturday previously. There were his calls from Rikers where he asked his friend to convince the victim not to testify before the grand jury. All of that is to say that the evidence of the defendant's guilt was overwhelming. The victim's narrative was amply corroborated, and it simply cannot be said that the verdict would have been different had the defense been able to cross-examine the victim about one isolated portion in a 3-hour-long recording that she made with the defendant.
Okay. Anyone have any further questions? Okay, thank you. Mr. Wu, we'll hear from you on rebuttal.
Yes, Your Honors, just a couple of points. Respondent's primary contention is that there was a lot of corroboration, but the whole point is that even evidence that appears to be compelling at first blush may look quite differently once you take into account other evidence. In this case, the complainant's prior statement that she had done more physically to Mr. Harvey is simply incompatible with her allegation of a brutal assault in May. And none of the other evidence cited by respondent is actually conclusive. And if a jury had been able to hear the complaint's own statement made on the recording that she made, that she had done more physically to Mr. Harvey, they may have agreed with Mr. Harvey that the allegation was fabricated and rejected her claim of assault in May 2010, just as they did with respect to her claim that he raped her in 2007. So on this record, it simply cannot be said that the exclusion of this statement was not prejudicial. It was deeply critical to the defense case. And again, the judge below recognized it because she criticized defense counsel for, quote, making the whole thing sound like it would be some fabrication when she saw what defense counsel was trying to elicit from the complainant. So that error was therefore prejudicial and requires reversal of the conviction. And, you know, the claim of judicial bias stands independent of any quantum of proof that the prosecution might present. The principle that a judge must be fair and neutral must be enforced regardless of how strong the prosecution's case might be. In this case, as I've noted, there are multiple instances in which the court evinced its bias in favor of the prosecution and the complainant, made a series of rulings that denied defense counsel of the ability to present their fair case to the jury. And for that independent reason, the conviction cannot stand and it must be reversed. Thank you so much.
Okay, thank you both very much. The next case for oral argument is Rivera versus Lopez Reyes. The appellant, Mr. Altman.
Yes, good afternoon, Your Honors. May it please the court. My name is Michael Altman. I'm with the Altman Law Firm, and we're appellate counsel for plaintiff appellant Mr. Rivera. I know I know Your Honors are familiar with the facts and the issues, so I want to jump right in. I have
Mr. Altman, I wonder if I could ask a question while you're before you jump right in, or help you jump right in. I looked at the records that you submitted on behalf of Mr. Rivera. A lot of these records were not affirmed, were not ultimately signed by the doctors who made the who had examined him at various times. And I was wondering, the judge below did not consider those documents, or was because they were not properly affirmed. Why was that? Why didn't you have any documents in here that were signed by those doctors?
I can't tell you why it was done that way. What I can say is, first of all, I'll get to it later. I don't think you should be reaching those issues. But with respect to the medical records, and again, I can't explain why it was done that way, but there are three bases on which those records should have been considered. First, and most importantly, defendants' doctors relied on the bulk of those records in forming their opinions. The doctors set forth the records they relied on. Dr. Gerson relied on 17 sets of documents. The 17th one was 10 studies. He set that out, you can find that at pages 294 and 296 of the record. And Dr. Mednick listed 23 records he reviewed.
Even though they did list them, did they in fact actually rely on those records in coming to their conclusions?
Yes, absolutely. Each one expressly provided that they relied on them. Dr. Grusin did that at page 303 of the record, where he said, based on the available history and medical documentation, I would conclude that. He then provided his opinion, so he expressly relied on it, and then he mentioned a number of the films and studies in his opinion, and Dr. Mednick at page 326 of the record expressly asserted that his opinion was, and I quote, based on the findings of my examination and available medical records. So
But
they
we don't know, excuse me, counsel, when he says available medical records, he may well not have been including those which were neither signed, proofread, nor sworn to, because he may not have considered those to be available medical records because they're not reliable. So
Well,
I'm not sure that your statement shows that he actually relied on the unsworn, unsigned, unproofread documents.
Well, when a doctor lists the documents he relies on, then discusses them, lists the documents he reviewed, discusses them, and then said he relied on the available medical documentation, I would submit that that means that he did rely on the documents that he listed. I don't really know what I could say beyond that. The second reason, they would be admissible, you have 6 affirmed reports, and I understand they're not signed. I understand that's an issue, but the reason for that is they were not prepared for litigation. These are a treater's medical records. He affirmed the reports. They said they were affirmed. And here's the third reason, which sort of meshes with the second, is that all of the affirmed reports came in a bundle of medical records from the medical treaters, and each for the treating medical practices, and each of those bore a signature from a treating physician. So I would suggest that that certainly made up for any failure to sign the individual reports. And those signatures for the city med records is at 385, and for the spine specialist records at 483. But if your honors don't have more questions on the records, I'd like to get back to my first point, which I think will show that you never need to reach the issue of the records. And that is that the sole basis upon which Justice Hummel found that defendants made a prima facie showing was a lack of causation. Now, the primary injury Mr. Rivera sustained was to his lumbar spine. Surgery was recommended for it. In the records that have whatever issues they have, there is documented extraordinary 45% range of loss of motion of the lumbar spine. As I said, that's his primary injury. Now, defendants submitted affirmations from 2 doctors. One, Dr. Mednick, did not offer any opinion with respect to causation whatsoever. The second doctor, Dr. Grusin, all of his opinion can be found at pages 303 and 304 of the record. And while he opined that Mr. Rivera's neck and shoulder injuries were not causally related, he offered no opinion with respect to his lumbar spine injury. That's the key injury here. And I respectfully submit, it's a very simple issue presented on this appeal. All we need to do is look at pages 303 and 304 of the record. If Dr. Grusin opined that his lumbar spine injuries were not causally related, then defendants made a prima facie showing. But if he did not offer that opinion, and I submit he did not, and I submit nobody can find it, and it's only 2 pages in the record, then defendants utterly failed to meet their burden, and you never need to get to the issue of the admissibility of the records.
Okay, if no one has any questions, we're going to hear from the other side, and we'll give you time to respond, Mr. Altman. Okay,
Thank you.
And thank you very much.
May it please the court, Gerard Ferrara, Scale Law Group for defendant respondents.
Mr. Ferrara, could you address counsel's contention that we should disregard the fact that the documents submitted by plaintiff were unsigned since your experts relied on those documents?
I would echo with respect, Justice Gosmer and Justice Kapnick, you both were sort of alluding to the law here, as well as the facts that make this substantial, and that is whether or not the doctor relied on these documents. The case law is somewhat well settled that merely, reciting a list of documents in your IME report, or even sort of whether it's in the opinion section, whether it's in the preamble, whatever the case may be, it's clear on the face that there's no indication that neither Dr. Grusin nor Dr. Mednick were specifically referring to these findings, and here's their opinion as to what this constitutes in formulating my opinion, why Dr. So-and-so I disagree with, or whatever the case may be. The doctors were simply listing the history that was provided to them as part of their examination. And I would argue that entirely fails to prove that any of those records are somehow, quote unquote, vouched for their credibility or authenticity. The argument is simply that in providing their full examination of what they reviewed in terms of preparing for their examination, both the physical and their report, those were simply.
Can I ask you something, Mr. Ferrara? I know that there were also medical records in this record that came from the New York spine specialist, where the plaintiff was examined, and where they indicated that he underwent lumbar spine surgery or procedures, joint nerve blocks for spondylosis. Now, I believe the plaintiff was only 29 or 30 years old. These are serious kinds of surgeries that people don't, go to very quickly. So, and it didn't show that there was that much of a history or any history. So why should we disregard that, not consider that may have been causally connected to this injury, those types of, that type of treatment for the plaintiff?
Well, with respect, Your Honor, and I'm not here to minimize treatment or lessen injury. The fact is, and of course, I'm not a doctor, but I do have some medical background. But the bottom line is what you're referring to, as many of these reports refer to, quote unquote, surgical procedures, is merely a nerve injection. It's a minimally invasive procedure. It's essentially the equivalent of an injection. Now, it is, of course, located in the back, but it certainly is a far cry from a surgical procedure or an invasive procedure. And to be perfectly blunt, is something that we see in many of these cases where plaintiffs attempt to sort of pad their treatment to make it appear as if the injury is more severe. As to plaintiff's age, I would argue beyond their age, the plaintiff here is some 280 pounds at 5'6", which any medical expert would qualify as obese. And that certainly reflects in some of his injury as well. There's also testimony the plaintiff conceded he spent time in jail, part of which was as a result of assaults for him fighting other individuals. So there's clearly a credible background as to where any of this person's prior injury may or may not have been ascertained. Here, I certainly respect, zealous advocacy for a client, particularly from an adversary. But here, the mountain of sheer misrepresentations are certainly clear, essentially on the face. The threshold law was designated to kind of eliminate these specific types of cases where these non-credible injuries exist, to eliminate the burden on these overburdened courts. And this could not be any more perfect of a case. You have a minimal impact here. In fact, there's no impact from any other vehicles or stationary objects. Essentially, the tire falls off and the truck stops where it's at. The plaintiff goes to the hospital to simply get examined and then doesn't follow up for any further treatment until a few weeks later. His total treatment is some 6 to 7 months in length. Plaintiff himself concedes, arguably, that the only injury categories he potentially can satisfy is significant limitation in 9180. And I would argue, particularly when it comes to 9180, that plaintiff misrepresents that this was not addressed or sufficiently addressed. The litany of plaintiff's own testimony clearly disputes any 9180 claim. The day after the accident, he's able to go to the defendant's house to collect his pay. Within just days of the accident, he's able to pack and unpack his apartment and move all of his belongings to a different apartment. He, within weeks, gets a second job with, I believe it's another Mr. Softy truck. No, I'm sorry, it's with King of Balloons, where he's fired shortly thereafter, not for his inability to perform his job, but because he's inappropriately flirting with 4 of his female coworkers. He then gets a job for another Mr. Softy truck, where he's working 7 days a week, 13 hours a day. All of this is in the record as part of plaintiff's own testimony. Within 4 months, he's working for another company, Eli Bread, where he concedes he's able to reach the top shelf, reach the bottom shelf. He's loading 40-pound boxes and bags of supplies to his delivery truck. It's pretty clear and replete in the record that 9180 is certainly not satisfied here. And as we argue, as plaintiff attempts to argue at least, that the lumbar issue is the main injury and was not addressed. It's clear in the record that both Dr. Grusin and Dr. Mednick addressed the lumbar injury. Dr. Mednick finds full range of motion in the lumbar spine with no issues. Dr. Grusin does find minimal restrictions, but opines that these are entirely inconsistent, they're subjective, and concludes that at best there's a resolved lumbar sprain. And as the court is well aware, sprains and strains, do not meet serious injury.
I think we got it. I don't think anybody has any more questions. So I'm going to let Mr. Altman respond a little bit to your arguments. Thank you very much, counsel.
Thank you very much, Your Honors.
Thank you, Your Honors. Counsel's descriptions aside, the record shows that we have a 25-year-old plaintiff who had no prior accidents, no record of prior injuries or treatment until this motor vehicle incident. Then for at least 6 months after, his treating physician found that he had extremely limited range of motion. He suffered a 50% disability for at least the first 6 months after his accident. He was referred to pain management and surgery was recommended. It's simply absurd to pretend that this is a result of degeneration. I point out that counsel did not point to any evidence that the lumbar spine injuries, were degenerative. There is no support in the record. I never claimed that defendants' doctors didn't address that the injuries existed or didn't exist, but they did not examine Mr. Rivera until 19 and 20 months after the accident, respectively. I just submit, because there is no evidence in the record of a lack of causation with respect to the key injury, the defendants did not meet their burden on the motion and reversal is warranted. Thank you, Your Honor.
Okay, thank you, Mr. Altman, and thank you, Mr. Ferrara, very much. Have a good rest of the afternoon.
Thank you, Your Honor. Stay safe and stay well.
The next case for oral argument is matter of Charrington versus New York City Transit Authority. Mr. Schwartz for the appellant. I believe you're on mute, Mr. Schwartz. We can't hear you. I think you're still on. It looks like you're. Oh, whoops! I think.
Okay.
Okay.
Now I'm on.
You're on. Go right ahead. Good morning. Good afternoon.
Hi. And I actually came to the courthouse, checked in there, and then ran back to my office.
Next week.
I miss seeing you guys. I actually did an oral argument a month ago or 2 months ago. It wasn't that long ago. Good afternoon. This case, I think, is on all fours with a case that I actually lost. Judge Gesmer was on the panel, I recall, in the Phillips, in Phillips versus New York City Transit Authority, or actually it was New York City Transit Authority versus Phillips, where the Supreme Court had found that the arbitrator's findings couldn't be dismissed, and that public policy just made those findings intolerable to the court. That had to do with a sexual harassment case, and there was a key phrase in that. This case involves a black employee who was twice confronted by a supervisor in a bathroom on the station level, where there's no question the arbitrator found that the supervisor was racially motivated by racial animus, that he was the aggressor, that he threw the employees, Mr. Charrington's telephone in the toilet, that he slugged him, and then Mr. Charrington got up and punched him in the face. And for that, he was punished with a 3-week suspension. And I think that the key thing that I want to read from Phillips is the court wrote here, the arbitrator's decision fashions a remedy that violates public policy. Moreover, it contains language maligning victims in an entirely inappropriate manner, including statements that it was incumbent on Melendez to take appropriate action if she felt that Aiken's comments were inappropriate. Such a blame the victim mentality inappropriately shifts the burden of addressing a hostile work environment onto the employee. The arbitrator's decision belies the reality of workplace sexual harassment. This decision here is on all fours with that, because this arbitrator found repeatedly who was the aggressor, that he was racially motivated, that he took the first action, that he threw Mr. Charrington's telephone in the toilet, and that somehow then Charrington still had an obligation to, quote, retreat, even though the whole thing, as the arbitrator found, occurred in a bathroom.
But isn't this, excuse me, Mr. Schwartz, isn't this rather different from Phillips in the sense that among the things that the arbitrator found is that, in fact, your client had a means of retreating that was realistic? And given that that finding by the arbitrator who heard the evidence, aren't we bound by that finding that there was an appropriate means of retreat that he could have availed himself of?
He didn't.
And especially in view of the fact that the Transit Authority has a no violence, sort of no tolerance for violence policy, which this would seem to violate.
But he didn't say that. He said Battaglia was a physical aggressor, first knocked cell phone out of his hand, then struck him in the chest. And then he said, I find Charrington had an opportunity to retreat. That's all he said.
Well, obviously, if he said he had an opportunity to retreat, then he was implicitly finding that there was a place he could retreat to, or that he wouldn't have had an opportunity to do so.
But
so it doesn't seem to me the arbitrator has to write out every word in order for us to find that he made a determination based on the evidence presented to him that Mr. Charrington had an opportunity to retreat, which he didn't avail himself of. I mean, I don't disagree with you that the facts of this case are not pleasant, and that Mr. Battaglia didn't behave well, but that doesn't necessarily mean that it's okay for Mr. Charrington to respond with more violence.
What we argue there is that this statement here that he had an opportunity to retreat is totally inconsistent with the rest of what the arbitrator writes, because we also have an irrationality objection to this award. The entire.
How is that? Could you show me what about that is inconsistent with anything else in the award? I don't see that that's inconsistent. He finds there was an opportunity to retreat, and I assume that was based on the factual testimony that he heard, which of course we don't have since there's no transcript.
Well, what we do have in the record is a statement from the Transit Authority that was part of the charges, which is on page 37 of the record, where Mr. Battaglia, his statement was, Mr. Battaglia stated to me while using the urinal, Mr. Charrington started videotaping him. He then knocked the phone from his hand, picked it up, and threw it into the toilet. Charrington then punched him in the face. He said he never threw a punch. The incident occurred, according to the charges, in a toilet at the station level. This is not like some big public restroom. This is a toilet that employees use to wash up, and Mr. Charrington was a cleaner who was using it to fill his bucket to go scrub the platform. So that's the inconsistency here. It keeps repeating that Battaglia he was provoked by Battaglia in a manner and to an extent which persuaded me we unjust to uphold his dismissal. Battaglia engaged, I'm reading from the award, page 73, engaged in conduct motivated and which overtly communicated racial animus, and which was hostile and grossly offensive to Charrington. And it was Battaglia who struck the first blow. Charrington's decision, albeit one made impulsively and impossibly under duress to strike Battaglia in the face. To then say that he that there's a consistency there by saying somewhere there was somebody somewhere in the toilet. We're not talking about some huge public restroom at Grand Central Station. We're talking about a toilet that employees use on the platform that the public doesn't use. It's just for employees. That there was somewhere to retreat to, despite the racial animus, the grossly offensive nature of it, the duress that he was under, the fact that Battaglia had thrown his phone in the toilet and struck the first blow. Those are all findings he makes. To then say, oh, but he had an obligation to retreat. This is an irrational. This one side doesn't flow from the other, and then
okay, I need you to wrap it up because I've given you several extra minutes.
That's fine. I've made my point.
Okay, thank you, Mr. Schwartz. You will have a couple minutes for rebuttal. Mr. Drinan, I might have Drinan. I'm sorry, I might have put Drinan. I apologize. You may begin. Right now, you're on mute, though.
Now?
Now we hear you.
Yes, it's Drinan. Thank you, Judge. Good afternoon. May it please the court. Robert K. Drinan for transit on this appeal. A number of things to say in response to Mr. Schwartz's argument and the arguments raised on appeal. The review of an arbitration award is limited to the four corners of the award, not other kinds of documents and things like that. They're useful, but the review is of the award. Mr. Schwartz will nitpick through the facts and try to select certain facts, such as there was no way to retreat. This is Arthur's conclusion. Because there was no way to retreat, he had to defend himself. And because he had to defend himself, and because some racial comments were made by Battaglia, Charrington could not be disciplined. The Transit Authority has a workplace violence policy because someone instigates a fight and someone responds. We have 50,000 employees. Those people that engage in altercations, they can be older or younger, they can have different races, all the demographics can change. But the workplace violence policy applies to everyone, right? And it applied here. So after Bolt and Justice Rivera's concurrence in Bolt, and we knew anyways that there's no arbitrary review with respect to rationality and arbitrary and capricious of errors of law or fact, there's no review and the claim by Charrington here that there was a wrong finding by the arbitrator and he detects some kinds of inconsistencies is not a basis to vacate the award. I would like to respond to the public policy argument because it is important, and we do recognize that. Transit has invoked public policy on a number of occasions to try to set aside arbitration awards. The first time was in Transit Authority against the TWU in 2002. Case reported at 99 New York 2nd 1. And Transit's argument there was that there were two employees who had violated safety rules, and Transit wanted them fired. And the lower courts vacated the awards, terminated the employees, and we went to the Court of Appeals, and it was argued in Borough Hall in Brooklyn, right? And during the argument of that case, where we were advocating public policy in this case, a safe workplace, Judge Kay leaned forward and she asked, what's the standard? What standard do we apply in this policy issue? And the attorney for Transit, because it was minor safety issues, couldn't say clear and present danger. So what he said was, let the case law develop those standards over time. And the Court of Appeals emphatically rejected that in a unanimous opinion that was really, really detailed in rejecting every aspect of our argument. But since then, there have been cases, right? In Phillips, the two decisions by this court in Phillips begin to lay the groundwork for what we believe would be a valid public policy review of arbitral awards, right? And the Court of Appeals denied leave on both those decisions. So, and Judge Edmead, we would respectfully request that this court is absolutely right when it ruled for Talani Melendez in the Phillips cases that employees have a right to a safe workplace and the employers have an obligation to ensure they have that safety and eliminate all kinds of discriminatory animus and things of that nature, right? Those are the obligations. The workplace is complicated. Those things happen, and we recognize that. But in this case, Judge Edmead was correct, right, in relying on Phillips to talk about the safety of an employee. That wasn't Battaglia that was trying to evade discipline here. And given the facts of this case, there's no room for public policy analysis or review or intervention with the arbitration award. And so we would respectfully submit that Judge Edmead's decision should be affirmed, but we do, and we would like to leave the court with this. We do recognize in the employment context, in review of arbitration awards that relate to employment issues, public policy does have a role, and this court is helping to define what that role is. Thank you very much.
Thank you very much, counsel. Mr. Schwartz, you have a couple minutes to respond.
Okay. As the lawyer that defended those two cases in Brooklyn Borough Hall, was a very interesting place to argue. The Transit Authority was arguing that there was some overarching public policy requirement to have safe bus drivers, and that the arbitrator's conclusion that someone who had 7 violations or 5 violations wasn't a safe bus driver, was safe enough to go back to work as a bus driver, violated public policy. And the court said, name it, what law, what rule, what section of whatever vehicle and traffic law. They couldn't do that. But here, as we cite, there is an obligation, just like there was in the Phillips case, for an employer to maintain a workplace free of racial discrimination. It exists both in Title VII, and it exists in the New York State Human Rights Law, and it exists in the New York City Human Rights Law, all of which apply to this employer. So unlike that case back in 2002, there is an express public policy that the arbitrator doesn't address here at all. Zero, doesn't address it at all. He uses racist, antagonist, et cetera, over and over. Second, in the Phillips case, if the court goes back over that decision, the arbitrator did not find that the employee engaged in sexual harassment, but he referred to another document.
Mr. Schwartz, you said that the arbitrator didn't address the public policy issues. Looking at the page that you cited, page 73, the arbitrator specifically says and considers as a factor in his determination that Mr. Battaglia engaged in conduct motivated by and which overtly communicated racial animus. And it was on that basis that he rejected the Transit Authority's request that Charrington be terminated. So he treated that public policy issue quite seriously in rejecting their request that Mr. Charrington be terminated.
I'm not sure he discusses it at all. He says that he basically discussed it as a provocation case, because it was my preliminary judgment that although Charrington did violate the authority's zero tolerance policy, he was provoked by Battaglia in a manner and to an extent which persuaded me it would be unjust to uphold his dismissal. I've done many arbitrations where provocation is a defense, right? It may not be a full defense, but it's a defense. It could be provocation for any reason, including a supervisor striking an employee first and the employee striking him back. Here, it was a racially stated, known, open, aggressive attack by a supervisor on an employee. And he doesn't talk about the public policy here, because the public policy here, basically what this leaves is any employee who is cornered and punched by a supervisor and threatened has to back off. That's not a policy that maintains a workplace free of racial discrimination. And that's our public policy argument here.
Okay, thank you very much. Thank you both. We'll certainly take a look at this carefully. Have a good rest of the afternoon.
Okay. Thank you very much for your time.
The next case for oral argument is Waldron versus City of New York. The appellant, Mr. Lane for plaintiff.
Yes, good afternoon, Your Honors. Stephen Lane, Constantine Associates for plaintiff appellant, Mr. Waldron. The issue that we're here today for is simply that the lower court improperly denied plaintiff partial summary judgment on 2 grounds. The first of which was labor law section 240(1), and then also in failing to grant partial summary judgment on 241(6). I'd like to address the 240(1) situation first. In this case, Mr. Waldron was a foreman and he had a fall down an unguarded, unrailed staircase that was prematurely opened. He fell about 8 to 10 feet.
Is it accurate to say it's unguarded? Because as you look at the pictures, there are walls right up against that staircase. So yes, if you told me that the failure to have a banister is an administrative code violation, I would certainly hear that. You would expect it to be a banister for such a staircase, but it's hardly unguarded. I mean, there were walls. I mean, I understand plaintiff says your allegation is that he grabbed for the banister, but if someone was just walking down and they'd hold on to the wall, they wouldn't have a problem walking down that staircase.
Well, I think the law is clear that even on staircases where there are walls, and it still requires handrails if, in fact, this is the sole means of access between areas of the construction site. And I'd also like to point out, prior to this, for 2 years or so, there were temporary wooden stairs that had rails, which was the sole means of access to the basement. They opened up this stair without rails.
I'm not saying that I won't get into whether he had to do it. There was another means of access to where he was going. It may have been a circuitous route, but there was another way for him to get there.
Well, and again, I respectfully would disagree with that. I mean, it's possible to get in anywhere. You could always break in, go through a window, but in this case, there was an equipment hatch, which was not meant for personnel to get in and out of the electrical panel room. The only other way was to go onto a different job site, somehow get through their security and enter through what turned out to be a locked door. It was 2 different job sites going on with different general contractors. So neither of those, as the lower court, I think, properly found, was a reasonable means for getting into this electrical panel room. The reasonable way and the way
this is probably, we can all agree, was the most direct route
of the stairway, certainly.
Yeah.
And I just point out to your other argument that the MTA's own safety guy, when he was showing a picture of this staircase with no rails, said this was dangerous. If I saw this, I would have shut it down until they put rails in, and then we would have let the workers, have the foot traffic that they had when the temporary rails were there. So not only was it dangerous, it was, was a foreseeable danger. The fact that it had walls on both sides, I don't think, I know shouldn't defeat 240 in this case. Again, there's no question that Mr. Waldron testified, and he's the only person who did, that when he started to stumble, he reached for the rail. Where the lower court went awry is that they found this correctly was a safety device. It was clearly defective because of no handrails, but they said there were 2 versions of how the fall began. One was that Mr. Waldron testified that due to the 1 3/4 or 2-inch differential between the hallway and the landing, he stumbled and then reached for the handrails and he was unable to get hold of them. The lower court said if that was the case, 240 would apply. She then says that, and Justice Sokoloff, I should say.
But there is some conflict, isn't there? Or at least a matter of nuances, whether there really was a difference in the level between the platform and the top of the staircase. I know there was evidence presented that there was, but there was other evidence. I think it was Shaman who testified that he didn't recall seeing any such difference in the level.
That's correct, Your Honor, and that's what the lower court based their decision, saying there were 2 versions. My point, and I'm glad you brought that up, is under either scenario, plaintiff should prevail on 240, whether he misstepped or whether he stumbled due to the misleveling. This case law out there where people have just misstepped off of loading dock, unrailed, 240 applied. There's the Bertelsmann case where there was cleaning fluid on the stairs, which started the fall. But since there were no handrails and he fell down the stairs, 240 was granted. So I think the court was right down the line until they made that. That's a distinction without a difference. How he started to stumble doesn't speak to the fact of whether the staircase was an effective safety device, which it could not have been due to the lack of the handrails.
Okay, counsel, why don't you hold your arguments as to 241-6 and anything else you want to make till rebuttal, okay? Let's hear from the city defendant first, please.
Good afternoon, Your Honors. May it please the court. My name is Dylan Pryor from Galbatucci Claw, representing the city defendants here. And the question presented by plaintiff on this appeal is whether the motion court erred in failing to grant plaintiff summary judgment under Labor Law 241 and 241-6. And it's respectfully submitted that the court should answer this question in negative. It's our position that the court correctly noted, the lower court that is correctly noted in their decision, that this is a case where there are two distinct versions of events of this accident. You had plaintiff's testimony that his foot encountered this 2 to 3 inch height differential in the seam between the stairway and the landing that caused him to lose his balance and fall. And then you also had witness testimony that there was a pretty smooth and flush seam there, which would indicate that plaintiff's fall was solely the result of a misstep, which would just be an unprotected common peril of the workplace rather than a statutorily protected elevation-related matter. I know.
But if this was his sole way, well, it wasn't the sole way of getting downstairs, but it was a very convoluted way to get downstairs to go any other way. If there is a problem with the differential there, helping him to get to the workplace, isn't that what 240 is supposed to be protecting against?
If there was a differential, the issue that was raised here is that you have different testimony coming from other witnesses that it
but
was.
we did look at the pictures. The pictures are in the record. There's a bunch of pictures
Right.
in the record, and I mean, it's not the biggest differential I ever saw, but there does seem to be a differential there that may have taken him off guard and then caused him to fall down this whole flight of stairs.
It's possible, but again, what you mentioned about the stairs being unguarded, which we'd previously discussed, and the multiple means of access, there is a difference between being the only route and being the best route, and this is a route that plaintiff had taken hundreds of times, and including earlier that day, and the likelihood of it being a simple misstep, I just don't see how that could automatically trigger 241 in this case. And there's also, in my view, a lack of testimony, a failure to establish really that the handrail would have even prevented the fall, or that the lack of a handrail was the proximate cause that caused this trip and fall. And there are several different versions of events, even that come up in plaintiff's testimony and in his papers, that whether he tripped on debris, whether there was an obstruction there. There's kind of just this back and forth that becomes pretty unclear to determine, and it leads.
Is there a view that this isn't a 241 case altogether? I mean, this is a perfectly fine staircase. As to the staircase itself, it wasn't put there as a safety device. And this is not what 241 was meant to protect. Against. I mean, this staircase was not a safety device. It wasn't meant to be a safety device. It was a permanent staircase.
Right. There's a view that the alleged accident is just a result of the plaintiff's own conduct and his actions, and that the city defendants did nothing to cause the accident. And again, the stairway in question as to whether it was a sole means of access, whether. And again, plaintiff was also not. I'm sorry.
Hi, this is Judge Mazzarelli. Was the entrance to the stairway obstructed in any way, closed off, barricaded?
It was not, and this was also not a stairway where the plaintiff was specifically working on. It was just a stairway that he was using it to access.
He was using it to access
the basement, the electrical room, right?
So if it's an open way and it's the most efficient way, and if you're keeping it open, isn't that an invitation to the plaintiff to use it?
Yeah, he had been using it routinely, and it was a part of his. I think his testimony is that on a typical day he would use it quite frequently to go up and down the staircase to get to the basement where he was working.
So you knew people were using this stairway.
Correct.
You were on notice.
There's just a question of fact as to what this alleged defect was, what the issue was, and whether it was just a result of his own inattention walking the hallway. Again, if he had been using it,
is there an issue of fact as to what caused his fall?
There is. There are several different, like I had mentioned, there are several different versions of the exact details of the fall, and even getting into into 241.6. Whether or not there was debris there is another issue. That there doesn't seem to be any type of accumulation of dirt, debris, or obstruction that's presented in the evidence, and so that would be under 12 NYCRR 1.7 E1. There doesn't appear to be any evidence of that, and these are all just questions of fact for a jury.
Okay, how about we hear from your co-defendant at this point? Thank you very much.
Sure, thank you.
Attorney for Electric, you there? I believe you're on mute.
Yes, let me unmute myself. Thank you. Sorry about that. Anthony Bono for the respondent Eaton Electric. May it please the court. I would like to point out initially that this plaintiff did not fall because of any defect with the staircase itself. And I would like to point out, more importantly, that this supposed height differential that the plaintiff testified to did not exist at the point where the landing met the top step of the staircase. This sloped portion of the hallway existed in the hallway where the hallway itself met the landing that led to the staircase. So this plaintiff stumbles when he feels his foot buckle and continues stumbling, takes another step. He feels his right foot buckle, takes a step forward with his left foot onto the landing, and then proceeds down to fall down the staircase, claiming that he attempted to reach for a handrail, and in argument on this appeal claims that he would have been able to grab it because the hallway was not so wide and he was not so far. The speculative testimony argument aside, the issue here is that this staircase is a permanent appurtenance that was not designed in any regard to prevent against elevation-related hazards. The fact that the plaintiff fell down the staircase is a result of his inability to regain his balance after he admits to stumbling on a sloped portion of the hallway that according to his own admission, was designed to accommodate the slope of the hallway coming from the first floor into the bi-level down to the basement to the top of this new landing that was installed. There is no actual,
which was certainly not a safety device and was permanently constructed that way.
Yes, this staircase was constructed to be simply a staircase to go from the.
But the hallway is certainly not a safety device.
Absolutely.
And you say that the hallway had a slope that was meant to have that slope.
That's true. That's what the testimony in the record reflects. So the issue here is that this staircase itself, whether it's a labor law 240 safety device or not, did not fail in any regard, certainly as with respect to the cause of this plaintiff's fall. Now, the argument that the lack of the handrails is the proximate cause of the injuries is entirely speculative. The plaintiff has no idea whether or not he was going to be able to grab onto a handrail and hold himself, from falling further while he's in the middle of a fall.
Well, if we were to order that these issues have to be tried, that would be one of the issues for trial, wouldn't it?
Of course. And I'm not making a sole proximate cause argument here. To be clear, I'm not suggesting that this plaintiff took a dive down the staircase after he was stumbling a few feet prior to the landing. What I'm arguing here is that the plaintiff claims in his affidavit on summary judgment that he always uses handrails and always looks for them. But when he testified, several years prior under oath, he testified that he wasn't looking for the handrail and he was simply walking down the steps following his coworker. So, the understandable argument that the plaintiff wants to make is that he would have somehow saved himself from falling down the stairs, but it's speculative, and that may be true, but that's for the jury to evaluate because the plaintiff's credibility is
Counsel, what's the purpose of a handrail?
I'm sorry, I didn't hear you.
What is the purpose of a handrail?
The handrail provides stability for someone walking down the steps, I would say.
Stability.
Yes.
Thank you.
And
the administrative code probably provides that stairway should have a handrail, but that's not the issue of this case.
I do believe that there is a distinction between the theory of liability under Labor Law 241 subsection 6 and the theory of liability as to a violation of Labor Law 240 being a proximate cause of the injuries in this case. See, the issue here is that there's just no dispute that this staircase not designed to prevent against elevation-related hazards. And frankly, I submit that there isn't one in this case. This isn't simply this is just not a scenario where the legislature contemplated, elevation-related protection with this.
Okay, but you didn't cross appeal to knock out that cause of action. You just don't want him. You just think that there has to remain an issue of fact to be tried. That's your position. Okay. I've given you a little extra time, so we're going to hear from Mr. Lane. You have 2 minutes. I want to ask you, Mr. Lane, what is the 241.6 industrial code provision upon which you are relying? It's not really the 241.6, but for a 241.6 case, which provision are you relying on? Is it the one that deals with handrails?
Correct, which is 2.7E, I believe. As to that, our argument is simple. There's not a lot of case law on it. There's 2 sentences in the section which apply to 2 different things. The first sentence is it applies to temporary and open staircase and requires guardrails, period. The next sentence, which we say is applicable here, is all staircases, all stairs require handrails, which are different than guardrails. So the second set, clearly, we're all in agreement that this staircase was a staircase and it didn't have handrails. Therefore, I think as a matter of law, that section applies. We found the 4th Department case where someone fell down the stairs. There seemed to be an issue that they were saying you had to fall over the stairs. The one 1st Department case we found was when someone fell over the stairs. We didn't find any others, but clearly it's a fall down the stairs. Handrails are to prevent you from falling down the stairs. Guardrails are to prevent you from falling over the stairs. Just a couple of other points.
Which you couldn't have done here because there were walls on both sides.
Correct. He couldn't have fallen over, but he could fall down. And there are numerous cases, and I'd just like to address Judge Friedman makes the point that this was not intended as a safety device, but there's case law in this department, numerous cases that find that permanent stairs that are the sole means of access between areas of the work site are safety devices. And if it doesn't have handrails, according to their own person's testimony, it's defective.
All those cases where the employee is required to be working on that staircase.
I apologize. The case, there's 2 ways in which, as you point out, that a staircase can be a safety device. One is if he's required to work on it, no question. That's not the case here. He wasn't working on it. But again, the second one, it's an either or. If it's a permanent staircase, which provides the only means of access between work areas, and he's required to use it for that meaning, then it's a 240 safety device. And if it's defective, as even the MTA says it is here, because it doesn't have handrails, and the lower court found it to be defective, a fall down that safety device, it doesn't matter what precipitated it. If, as in Branzima, you slipped on cleaning fluid, you tripped over your own feet, once you fall down a defective safety device, a safety device does not prevent you from falling from one level to the other, which is exactly what happened here. 240 is triggered. The other arguments are all about negligence, comparative negligence, tripping, doesn't matter.
But we're assuming that this stairway is a safety device.
Well, I'm not assuming. I'm saying under the law as I understand it, and we briefed it, and the lower court found this is a safety device in this case.
Okay. Thank you very much, all counsel, for your arguments this afternoon. Have a good rest of the day.
Thank you.
The next case for oral argument is Merchants Mutual versus Dunham Piping. The appellant, are you here?
Yes, Your Honor, I think so.
Okay, good. We can hear you and you may begin. Good afternoon.
Thank you. Good afternoon. May it please the court. We're here today on an appeal of a summary judgment motion and a default judgment motion that we would submit were improperly denied by the court below. It's a non-cooperation disclaimer in a declaratory judgment action. And Merchants disclaimed coverage to Dunham Piping, which is its insured, based on its failure to cooperate with the defense of the underlying action. And we would submit that we established the non-cooperation of the insured.
So, but you talk about the lack of cooperation and you point to Mr. Dunham's lack of cooperation, but there were people who were cooperating with you Hernandez was ready to cooperate, and there were others who were ready to answer questions and to talk to, and probably would have appeared for an EBT. Why don't those ex-employees of Dunham Piping refute your claim of lack of cooperation?
Well, Your Honor, this is certainly a point that was made in the respondent's brief in this case, and I would submit that it's not a correct reading of the non-cooperation case law. So if you look, there's no case that's cited in respondent's brief that requires the insurer. The insurer already has a very high burden to meet a non-cooperation disclaimer, right? I would submit that there's no case that says you have to show that every single employee of an insured entity is not willing to cooperate with you in order to establish a non-cooperation defense. Certainly, there's some indication that Ms. Hernandez had spoken with the investigators at very early stages of the claim. It looks like the investigator also spoke with a couple other employees, but there's also indications that Ms. Hernandez had stopped cooperating altogether at that earlier stage. I think she's an office manager who was located working out of her home in North Carolina. I think it's too speculative to say that those employees could have met the cooperation standard in this case.
Well,
The other thing-
wasn't she providing you documents? I mean, the fact that she was in North Carolina doesn't mean that she can't provide you some of the documents that you were looking for, and giving you the names of some other people that you could speak to other than Mr. Dunham himself.
Yeah, she did provide some documents. If you look at the records of those communications with Ms. Hernandez early on, there is an indication that she did provide some documents, but it wasn't a full document disclosure. And if you look at sorry, Judge, go ahead.
Counsel, this is Justice Gassmer. As to Dunham Piping and Dunham Plumbing, you don't even really have to go to whether or not they cooperated because they didn't answer. Isn't that right? Isn't that really the simpler basis for your motion for default judgment?
Well, that's certainly true. All of Dunham Piping and Dunham Plumbing both didn't answer, which I suppose is not altogether surprising in a non-cooperation case. So in that theory, they have admitted all of the allegations pled against them in the complaint, which would, include, there's certainly allegations in there about their.
So how does that interact? How does that interact with the other parties who claim they're additional insureds? Pine Builders Corporation, Caton Realty. How does their non-cooperation affect your getting out of having to provide defense and indemnification to those other defendants in this case, or third-party defendants?
Yeah, Judge Friedman, I think this is an issue that if you look at the supplemental record, which has the transcript of the oral argument below, I think this is an issue that got the trial judge kind of tied in knots and a little bit confused. There's no claims in this case about Pine or Caton's entitlement to additional insured status. If they are additional insureds or not, I don't know the answer to that question. It's not part of this litigation. They would have their own independent duty to cooperate as an additional insured under the merchant's policy. To this point, my understanding, I don't believe this is in the record, but my understanding is that Merchants has denied their claim for additional insured status and is not providing them with a defense or indemnity at this point as it respects to the underlying action. But the fact that, say that the disclaimer is upheld with respect to Dunham, that does not in and of itself mean that the putative additional insurance.
There was a summary judgment motion made below in front of Judge Crane. What's the status of that motion?
I believe Judge Crane denied that motion. I think that's in the record.
As premature, right? Basically, it's because it's premature.
Yeah, the only thing I would say, Your Honor, is, and it was a little bit tough because if you look at the transcript, it kind of goes really deep into these additional insured issues that, again, I would maintain are not relevant to this case.
Did anybody even brief those additional insured issues downtown?
No, Your Honor. Okay. That was brought up sua sponte, as best I can tell.
Okay. But those motions remain to be decided, do they not?
No, I think if you look at the decision,
they're denied. You're right. You said that they're denied. I'm not disagreeing with that, but those issues remain undecided.
The additional insured issues, is that what you're saying, Your Honor?
The summary judgment motion. I mean, they were denied as premature below. Why would we take a stand on that at this point?
I'm not entirely sure that I'm getting the question, but let me see if I can try to answer it. Our position on this appeal is that there was a default motion against the non-appearing parties and a summary judgment motion. Pine Builders and Caton
against everyone else, right?
Correct. They're notice parties because they're parties to the underlying action.
So you're saying your claims really aren't against them?
Correct. They're just here to be bound by the coverage determination that's made herein. Do they need to be here? We could have started this action without them, right? We could have just included the underlying plaintiff.
Well,
and
let me ask you
insured.
this. Suppose we agree with you that you should have gotten a default judgment against the Dunham defendants. What happens to the rest of this?
The rest of the case should go away, Your Honor, because it's one claim in the complaint.
Not because
right?
you expect us to now grant the motion for summary judgment against the other defendants, which was denied below as premature.
No, I do think that if you do agree with me that I'm entitled to a default against the Dunham defendants, then I think you should necessarily agree that I'm entitled to summary judgment against the notice parties, because there's only one claim in the complaint, right? The only claim is that we're entitled to a declaration of no coverage based on non-cooperation. So that relief is the same against the non-appearing parties as it is against the appearing parties. There's no other evidence, right? It's what Judge Crane, I think, missed was I can't take a deposition of my non-cooperating, non-appearing insured. Right? I can't ask them about why they didn't cooperate. If they wanted to show up for a deposition, perhaps they would have shown up for the one they should have in the underlying action. There's enough. We've made the decision to disclaim coverage, right? Merchants issued that disclaimer for non-cooperation. They've decided that at this point, we have enough to move forward with this disclaimer. It's not like there's things subsequent to the disclaimer that are going to change that.
So the thing is, if you, to follow up on what Justice Friedman said, if we were to agree that you are entitled to a default judgment on that would be on all your claims against Dunham Piping and Dunham Plumbing, then you as the plaintiff, are you continuing your case against the other defendants? I mean, even if we don't grant you summary judgment, what's left? What claim do you have against them? Which one of your causes of action goes against them?
They're only included in the lawsuit as parties who have a potential interest in the outcome of the case who would be bound by the determination. So I suppose, Your Honor, if you were inclined to grant default judgment as against the insured and the underlying plaintiff.
Well, let's suppose to add to Judge Kapnick's question, suppose we granted you a default judgment against the Dunham and then said, well, this is otherwise affirmed. What would your position be on that?
Well, Your Honor, then the court would have issued an order saying that Merchants is entitled to a declaration of no coverage as against its insureds. At that point, I believe that order is enough for there to be a finding that there's no coverage for the insured with respect to this incident. And then
who's to make that finding? Is it us, or could we leave it to Supreme Court to deal with it?
If you grant the default motion was for the declaratory relief demanded in the complaint. So I think that finding would come from this court.
All right, you know what? Can we hear from the respondent, and then we'll see what other questions we might have for you. Thank you.
Hi, good afternoon, Your Honors. It's Andrew Showers for defendants, respondents, Catan Realty and Pine Builders. This is a case where the lower court's order should be affirmed. It properly denied Merchant's motion, finding there were numerous questions of fact.
Excuse me, counsel, what questions of fact are there? I'm sorry.
Go ahead. Yes.
What questions of fact are there as to the default by Dunham Piping and Dunham Plumbing, which didn't answer?
It didn't answer, Your Honor, because it wasn't appointed counsel. It wasn't appointed counsel. It was afforded counsel in the underlying case that's over in Kings County, but Merchants did not.
In this case, it was sued separately. It had an obligation to appear and answer. It didn't appear and both of them, neither of them appeared and answered. They're not entitled to appointed counsel in this case. So why I don't understand what questions of fact there are as to the the applications for a default judgment as to Dunham Piping and Dunham Plumbing.
Your Honor, they don't have, they have, this is a motion for non-cooperation. And they have.
It's a motion for a default judgment. You have defaulted. Why shouldn't the appellant get relief?
Because the reason why they've defaulted is because they didn't, the carrier had notice of this claim. They had a valid policy and they didn't appoint any counsel to defend the claim.
So why didn't you need to come in and put in your answer and litigate that, which you didn't do? So when you didn't do that, what happens is there's a default against you.
Your Honor, I'm not the attorney for Dunham, the Dunham entities. I'm the attorney for Catan and Pine.
But you said that we shouldn't grant this motion at all. Part of the motion is as to them. You seem to be taking a position that we should not be granting the default judgment. Are you taking a position as to whether or not we should grant the default judgment which plaintiff seeks against Dunham Piping and Dunham Plumbing?
I'm taking the position that their motion should be denied in its entirety and the lower court's order should be affirmed as to questions of fact.
But I'm still trying to understand what the question of fact is. They are Dunham Piping and Dunham Plumbing are each defendants in this case. They did not answer. That entitles the plaintiff to a default judgment. Plaintiff is seeking that. What is the question of fact as to the plaintiff's entitlement to a default judgment against Dunham Piping and Dunham Plumbing?
Your Honor, it's an insurance company taking a default against its own insured that it didn't appoint counsel for. And it has a valid insurance policy. And it knows of the people.
It doesn't have an obligation to provide insurance in this case. It doesn't have a
declaratory judgment case.
Right. It doesn't have an obligation to provide them counsel in the declaratory judgment case.
Your Honor, this is all a strategic move on behalf of merchants to avoid coverage.
Okay, let me ask you this, and correct me if I'm wrong. You know, as you say, a strategic move, but it seems, you know, your strategy has to be, you've got to oppose this motion for a default judgment. You've got to oppose this request for relief by the appellant in front of us because it suits your interest as representing the other defendants to keep Dunham Piping and Dunham Plumbing alive, to keep their claims alive because it helps you in terms of being an additional insured, etc. So, but well, they're not your clients per se, but the fact remains, merchants moves for a default against Dunham. Dunham doesn't answer. There's a default against Dunham.
And if that's true, where does that leave you? Your claim is that you were an additional insured on a policy that merchants is saying, you know, we're going to disclaim because of non-cooperation. Can you still, in the underlying personal injury action in Kings County, litigate the issue that your clients are additional insureds under the merchant's policy, and can the judge there deal with that in the context of that litigation?
Those issues weren't briefed in this appeal, Your Honor. We will certainly make the argument that we are entitled to additional insured status and defense and indemnity from merchants in the Kings action as well. But that issue is not before the court here, I would submit.
I mean, and what about the motion for summary judgment? What if we find that the merchants is entitled to a default judgment? What happens to that summary judgment motion that was denied below, basically because it was premature? What should happen to that?
It should be denied. The summary judgment motion should be denied. They did not reach the heavy burden that is imposed upon insurance carriers for disclaiming coverage to their insureds.
To fight another day about it in front of Supreme Court here.
Yes, it's a question of fact. I mean, the records show that merchants strategically, it had all of these employees lined up. It chose not to produce any of them. It chose not to give their insureds a defense. it withdrew counsel in the King's action, and it knew that it had 3 other employees that it had volumes of information from about this entire incident, and they chose to rely upon Dunham, the fact that Mr. Dunham wasn't cooperating, as the sole basis. The Mount Vernon case in the second department is right on point here.
Okay, we've given you a lot of time. Does anyone else have any further questions for this counsel? Okay, thank you very much. It is a little confusing. Can we hear from Merchant Counsel? You have 2 minutes on rebuttal. Thank you.
Yeah, I'll just try to briefly touch on a few points that came up, Your Honor.
Thank you.
The first one, the idea that this is some strategic backhanded maneuver by merchants to try to weasel its way into a non-cooperation disclaimer, I don't think is supported by anything that's in the record. If you look at the communications, it was underlying defense counsel who said that Mr. Dunham was the one who they wanted to have appear for the deposition. It wasn't like merchants was telling underlying defense counsel, hey, merchants, make sure you only talk to Mr. Dunham. Mr. Dunham was the owner of the company. He's the one who signed the contract for the work that was at issue. This wasn't some type of way around trying to produce a witness who we knew wasn't going to show up. It's clear that we tried to get a witness to show up. That's why we hired an investigator and sent out cooperation letters and those sorts of things. I think that the court has it right that there is no obligation on behalf of merchants to provide counsel to Dunham with respect to this particular matter. Sure, there was a requirement in the underlying case.
Well, that's what you're bringing this case is to justify you not having counsel for them in the underlying case. You're trying to, right?
Exactly. An insurance policy covers, you have to defend claims for bodily injury or property damage. This is a contract action. It's not within the defense obligation, therefore no defense was provided. The final thing I'll say, Your Honor, is I don't think that the case that Mr. Showers referenced is on all fours with this matter at all. That was a decision where it noted that the principal had told the insurance company, he didn't really have much information about the case. There was a notation in there that he was never made aware that not appearing would lead to a disclaimer of coverage for non-cooperation. Here, if you look at the letters that Mr. Dunham was sent, it's very clear that he was advised time and time again that not appearing and not cooperating would result in a disclaimer. So our position is that the order of the court below should be overturned and that we're entitled to the relief that is demanded in the complaint.
Okay, well, thank you both very much. Have a good afternoon.
Thank you very much.
Thank you, Your
Honor. The next case for oral argument is Handelsman versus Llewellyn.
Good afternoon, Your Honors.
Mr. Gorman, is that you?
Yes.
Okay.
Can you hear me?
Yes,
Okay.
we can. You may proceed.
Good afternoon. Ken Gorman for the plaintiff and appellant, Matthew Handelsman. This case comes down to 2 simple issues. Number 1, whether Llewellyn crashed into the plaintiff's vehicle because he was fleeing a phantom driver with a gun, or number 2, if the accident was caused by the city's reckless high-speed pursuit of Llewellyn in a densely trafficked and highly populated urban area. And although the trial court acknowledged that it had no authority to make credibility determinations, this is exactly what it did when it held that Llewellyn's testimony cut the chain of causation and that the police officers did not get close to his car.
Mr. Gorman, this is Justice Gasmore. I have a question. What evidence do you have that the reason for the crash was that Mr. Llewellyn drove recklessly because he was being chased by the NYPD vehicle, as opposed to just because he was driving recklessly?
The NYPD officers, especially Patrick Jean and Corporal Linsky, testified that they were pursuing him. Llewellyn's testimony could not have
I understand that was, I'm sorry, maybe my question wasn't clear. I understand that they testified that they were pursuing him, but what evidence is there that their pursuit of him caused him to drive into the plaintiff's car?
They were traveling at speeds of 80 to 100 miles an hour. Over a period of at least 1 to 3 minutes, and they were right behind him. They were only 1 to 2 car lengths behind him. At that high rate of speed, with a police vehicle chasing you at such a close distance, there's no way that the police could sever their actions from the chain of causation under these.
But hasn't it been held that the fact that the police are engaged in a high-speed chase of someone that they're pursuing, that does not constitute reckless conduct.
Depends what circumstances we're dealing with. For running a red light, no. For something more severe, like a shooting or robbery or something that endangers the public, I can understand that. But merely running a red light, absolutely not. And I mean,
red lights, Counselor. This is Judge Owen. I thought you ran through like red lights.
They testified that there was contradictory testimony as to what he was doing immediately before the accident. Before the accident, there was testimony he one red light. That was it.
Didn't he also testify, or isn't something in the record where he says that he started speeding the way he started driving the way he was driving because somehow he cut off a car, the car pulled up alongside of him, someone flashed the gun at him, and that's when he took off?
Llewellyn testified that he was being chased by some phantom driver with a gun, but with a gun, but that has nothing to do with the chain of causation, because Llewellyn admitted that he was only being chased by this driver for approximately 6 seconds. And this phantom driver only pursued him and turned off at the intersection of Furman Avenue and East 241st Street. Now, if you look at the maps in the record.
In this case here, the NYPD vehicles did not strike or harm anyone, correct? I mean, the NYPD vehicle was chasing, but thank God, it didn't hit anybody. It didn't hit other vehicles, correct?
No, it didn't. That's true, but the case law doesn't say that the NYPD vehicle has to make contact with the suspect's vehicle in order to get past summary judgment. I mean, you're saying
it's a proximate cause, that their actions are at least a proximate cause of the accident and injuries to your clients.
Correct, not the proximate cause, but a proximate cause, which is sufficient to get this case before a jury, which is all we want. I mean, in Foster versus Suffolk County, which we haven't discussed at page 33 of our brief, the Second Department held that summary judgment was properly denied because there were questions of fact as to what occurred moments before the accident, as to whether the police officer should have terminated the pursuit, which was conducted at high speeds in a residential neighborhood like this case, and the suspect dissipated several traffic control devices and narrowly avoided collisions with other cars at earlier intersections. Similarly, in Lopez versus Town of Gates, the Fourth Department held that summary judgment was properly denied, where there was evidence that the average speed of the pursuing vehicles, officers, exceeded 90 miles per hour, and that the collision occurred within moments after they terminated the pursuit. The facts of these cases are directly on point, and there is a fact as to what occurred.
How does the prior decision from this court concerning your clients, the 205E claim, I think that's the firefighters rule claim, how does the fact that our decision impact this decision then?
It impacts this decision because it found that there were two versions of events and there were questions of fact, which is exactly why.
Because the firefighter rule, basically, on the common law, bars claims that police officers get injured in the line of duty, correct? And the rule sort of ameliorates that type of harshness, right?
Yes, but it ameliorates the types of harshness because it also there's no contributory negligence. But there is a violation of the VTL in this case. I mean, there's plenty of violations of the VTL in this case.
Because I want to turn this around and say that, the way I look at it is that there's also testimony from your clients about how that they were trying to assist the NYPD in apprehending or at least stopping the vehicle, unless I misread the record here, right?
No, I did not see that anywhere in the record. They were stationary. They were talking to a confidential informant. They saw the chase, and when they saw the chase, the driver of the plaintiff's vehicle, Brian Hess, pulled over.
Doesn't the chase get really high speed? Doesn't it become a high-speed chase after the city police officers put on their lights and sirens? It's then that Llewellyn takes off at the really high speeds.
Yes, but they should have called this in. and the regulations required it. And even though it's not the determining factor, it is a factor. And the police defendants all admitted that it was dangerous to chase Llewellyn.
When you say they should have pulled us in, how long does the whole thing go on?
It goes on for approximately 1 to 3 minutes, but I mean, 10 seconds could be a significant amount of time.
I mean, you're in the midst of a high-speed chase, and you're supposed to be calling it in within that 1 minute or so.
You're supposed to be calling it in.
And not calling it in becomes the factor which makes them liable.
Well, the NYPD vehicle pursuit policy, section 212-39, requires officers to radio command before, not during, before engaging in a pursuit. And that's at page 1651 of the record, restricting them from making the unilateral decision of engaging in a high-speed pursuit. The court also failed to consider that Corporal Linsky and Downs were familiar with the patrol guy's procedures for engaging in vehicle pursuits. Downs admits this at page 340 of the record. Corporal Linsky admits this at pages 734 to 735 of the record, which they failed to follow.
Okay, let's hear from the city defendants, and then you'll have a couple minutes to respond, Mr. Gorman.
Yes.
Thank you.
Good afternoon, Your Honors. May it please the court, Amy McCampbell on behalf of the respondent city. Your Honors, Supreme Court properly granted summary judgment to the city here for two independent reasons. First, the city showed that its officers did not act recklessly as a matter of law. And second, the NYPD officers did not cause the car accident. Now, on the first point,
so could you deal with that that they didn't act recklessly as a matter of law? They're in an area that's populated, densely populated, and they start going at what various people have said is 80 miles an hour following a car, and there's other cars on the road. How is that as a matter of law? Maybe ultimately, but as a matter of law, not reckless.
Sure, Your Honor. So the testimony that plaintiffs are seeking to rely on is the seconds in which the cars were exiting the bridge. The plaintiffs say that the NYPD vehicle was driving at a high speed in close proximity to Llewellyn's vehicle. And
Right.
Courts have repeatedly held that allegations that merely pertain to speed and proximity to a suspect's vehicle is not enough to create an issue of fact with respect to recklessness.
I mean, the courts who have held that, there are courts who have held that, but there are also courts who have held that in circumstances like these, like the cases that Mr. Gorman cited or Ferrara versus Village of Chester, that these kinds of facts of fast travel combined with pursuing a car in densely populated area may constitute recklessness and have denied summary judgment. So why isn't this more similar to the cases where summary judgment has been denied with this kind of fast chase for an extremely minimal provocation of passing one red light, failing to stop at one. As far as I read the record, the only evidence of criminality is that Mr. Llewellyn allegedly went through one red light. So it's a combination of the fast speed plus lack of criminality on the person they were, or minimal criminality on the part of the person they were pursuing, plus the high level of the density of population. So it's not just the high speed that we're talking about that would justify denial of the motion for summary judgment. Wouldn't you agree?
Well, Your Honor, I think there's two things that distinguish this case from the cases in which plaintiffs are seeking to rely on. One is that the cases in which they rely on, there's evidence of a police chase that lasts for more than mere seconds. Here, the plaintiff's testimony only pertains to the seconds in which the police car is exiting the bridge. And the Court of Appeals has repeatedly stated that when you have evidence of a momentary lapse in judgment, which is all that plaintiffs are pointing to here.
I think there's a question of fact as to whether it's seconds or minutes. Some of the testimony is as to seconds, but there's also testimony by several witnesses that it went on for several minutes.
No, Your Honor, there's
can't pick and choose which one I mean, if we're talking about whether or not there's a question of fact, we have to look at all of it and not evaluate it at this point, correct?
Your Honor, there is speculation from the plaintiffs that the chase went on for minutes, but the only
testimony by the independent witnesses like Mr. Goro.
Yes, Your Honor, his testimony was only as to the seconds in which the vehicles exited off the bridge. And moreover, Your Honor, the second distinction is that here the testimony that plaintiffs seek to rely on is incredible as a matter of law. Plaintiffs are testifying that the NYPD vehicle was driving at 80 to 100 miles per hour and that it was less than 2 car lengths behind Llewellyn's vehicle. But the NYPD car was not involved in the crash, And according to the consistent testimony of all the witnesses, the plaintiffs, the NYPD officers, Llewellyn, and the two non-party witnesses, the NYPD car arrived safely at the scene of the crash within moments. Now, plaintiff's own expert says that at a speed of 90 miles per hour, the stopping distance on this roadway is 640 feet. So plaintiff's allegations with respect to the speed and proximity of the NYPD vehicle to Llewellyn's vehicle is frankly incredible, and it's not enough to withstand summary judgment. And
doesn't the evidence also show that it became high speed only after they put on, you can point to the fact that it's just they passed the red light, but it becomes high speed after the police officers put on their lights and sirens.
Yes, Your Honor, all the witnesses agree that the police officers' lights and sirens were on, which is another thing that distinguishes this case.
And that's when it became really high speed. And that's when these allegations of 80 to 90 miles an hour are after the police officers put on their lights and sirens.
Yes, Your Honor. And again, in some of the cases that plaintiffs are citing, in which courts found that there are issues of fact with respect to recklessness, the police did not have their lights and sirens on as they did in this case. And a second independent reason that summary judgment was properly granted to the city here is that there's no causation from the NYPD's actions to the accident. Llewellyn has consistently stated that he was fleeing from a man with a gun, not from the NYPD officers. He did not say, as plaintiffs argue, that he was only fleeing from a man with a gun for 6 to 7 seconds. He says he doesn't know how long the man with the gun was following him. On page 1065, 1066 is a record. He says he heard the sirens 6 or 7 seconds after he started speeding, which is very different.
But are you also disregarding the evidence in the record that Mr. Llewellyn tried to interfere with the testimony of some of the other witnesses? It seems to me that on a motion for summary judgment, we have to consider all of the evidence concerning Mr. Llewellyn, including the evidence that he tried to influence how other witnesses testified at their depositions and EBTs.
Well, Your Honor, the plaintiffs point to the testimony of a non-party witness, Gil, which says that Llewellyn asked him to testify this and that. But what Gil said Llewellyn asked him to say is the same thing that Llewellyn himself said under oath. So Llewellyn was simply, if that's to be credited, which it should be at summary judgment, all he was asking the other witnesses to say was to agree with what he himself had testified to under oath. And
but it's the fact that he tried to influence another witness which undercuts his own credibility, isn't it, counsel? The fact that he is an interested party who's seeking to influence how other people testify is something that creates a question of fact as well, isn't it?
Well, I don't think so, Your Honor, here, because here the witnesses knew each other. They had prior conversations. We also know in the record that Handelsman, the plaintiff, contacted Llewellyn to talk to him about the event. So the parties were talking here between each other. And in any event, Your Honors, there's no issue of fact with respect to causation because the NYPD officers did not cut Llewellyn off. They did not make any attempt to stop him from being able to pull over. And that's what happened in the Foster case that plaintiffs point to right now.
This is Judge Owen.
Why is it that Mr.
Judge Owen was, I'm sorry.
From what I hear is the best evidence you got is that, in fact, these cars were supposedly going, the NYPD was going at such a high speed. They should have been part of the crash too, right? I mean, if they're flying over the bridge like everyone's saying they are, and Llewellyn hits the Westchester PD's car, the next car that's going to be in part of that crash has got to be the NYPD's car, because there's no way, according to their expert, will be able to stop in time to avoid a crash.
Yes, Your Honor. There's no way that a car traveling 80 to 100 miles per hour could stop on a dime. The NYPD car would have either been involved in the crash or flown past the site of the crash. And yet all the witnesses agree the NYPD car was right at the scene of the accident immediately after it happened and was completely unscathed.
Somehow they're going 80 and 90 miles an hour, a car length behind, and they managed to stop without hitting anyone.
Exactly, Your Honor.
Judge Mazzarelli, did you have a question?
Yes, I was curious about Mr. Llewellyn's plea to a violation of reckless driving. What impact that might have on the plaintiff's case.
Well, there is a dispute of fact whether the plaintiff's actions or Llewellyn's actions were the cause of this accident, as this court has previously recognized in denying summary judgment for the plaintiffs. Certainly, Llewellyn has admitted he acted recklessly in his plea. But that doesn't really have any bearing on the city, which has shown that its officers did not act recklessly and that its officers did not cause this accident.
Would you address the point of the failure of the police officers to call it in?
Sure, Your Honor. So courts have repeatedly held that allegations about a failure to call a dispatcher do not create an issue of fact with respect to recklessness. The Court of Appeals recognized that in Charrington. This court recognized that in the Akil case. And more broadly, courts have time and time again held that mere failures to follow police internal procedures and protocols do not create issues of fact with respect to recklessness. Recklessness is a higher standard that requires a showing of conscious indifference to the safety of others. So merely saying that you didn't follow this page of the patrol guide does not create an issue of fact with respect to recklessness. And we've cited multiple cases in our brief for that proposition, Your Honor.
Okay.
Unless Your Honors have any further questions,
No,
we would ask you to affirm.
Thank you
Thank
very
you.
much. Mr. Gorman, you have 2 minutes.
Mr. Gorman, could you address the issue about how the NYPD car could have avoided being part of the crash if it was traveling as fast as you claim?
Very simple. The reason why the police defendants were able to avoid crashing into Llewellyn's BMW was because he lost control of his vehicle and went into the opposite lane of traffic over the double yellow line while the police defendants went straight forward. It's as simple as that. Llewellyn lost control. He went into the opposite lane of traffic. The police defendants went right past him. But they were always the evidence. The evidence is clear that that they were only 1 to 2 car lengths behind Llewellyn at all times, and it doesn't take an expert to make that determination. We're not asking the court to find that this was reckless conduct. We're just asking the court to let this go before a jury who can determine whether it's reckless. And these police defendants knew the risks. Patrick Jean testified that engaging in a high-speed chase in an urban area was dangerous at page 482 of the record and placed the public at risk. Corporal Linsky, who was driving the vehicle, he testified at page 728 and 731 that he had never engaged in a vehicle pursuit prior to this incident. But yet he knew that East 241st Street was a heavily traveled area and that this was a highly populated residential area. And most importantly, this was just not a momentary lapse of reason. You cannot go from 0 to 100 miles an hour in a moment.
Was there any testimony as to how long this situation took from the time that they started following Llewellyn to when he hit into plaintiff's vehicle?
We have Patrick Jean, who testifies at page, I think it's 496 of the record. He states that it lasted approximately 3 minutes. And we have Corporal Linsky, who testifies at page 665 of the records that it was 1 to 2 minutes. And Llewellyn also states that he was being chased by the police at pages 1069 to 1070 of the record. So, I mean, and with regard to Llewellyn being chased for 6 seconds with this phantom driver with a gun, irrespective of whether it was 6 seconds or 10 seconds, the bottom line is that Llewellyn testified that he turned off at the intersection of Furman Avenue and East 241st Street, which every single officer in this case testified was before they saw him. So if he turns off before the intersection that these officers saw him at, this phantom driver with a gun was exactly that, a phantom for all intents and purposes of this case.
Okay, any further questions? All right, thank you both very much. We'll certainly take a look at this further.
Thank you, Judge.
Thank you.
Thank you.
The next case for oral argument is State Farm versus AK Global. We just have the attorney for State Farm here, correct? So we've given you 4 minutes if you'd like to bring anything to our attention.
Thank you, Your Honors. Good afternoon. Can you hear me?
We can.
Thank you. May it please the court, my name is Stuart Bodoff of Rifkin Radler, Appellate Counsel for Plaintiff Appellant State Farm. The Supreme Court should have granted State Farm's motion for leave to enter a default judgment. Less than a year ago in State Farm against Surgicorp, on the same type of proof as submitted here, this court reversed the Supreme Court and granted a default judgment in State Farm's favor on 2 grounds: that the collision was not an accident and that the claimants failed to appear for EUOs. State Farm requests that this court do so in this case as well.
Wasn't there some problem as to service on some of these defendants? Isn't that part of the problem?
Certainly, Your Honor, and that is, I think, the toughest issue that State Farm has here with regards to certain defendants. Most of, or all the provider defendants were served through a Secretary of State or personal service. One of the individual defendants was served personally after nail and mail was attempted. So I don't think there's an issue there. The remaining.
How about Gidden and Lasso?
And
don't you have service? Don't you have service? Judge Chaffee found that you had service problems as to those defendants. I mean, there's no answer apparent to the service problems that she found.
What I can say about service on those, Your Honor, the service was attempted 3 times. It could clearly, the affidavit of service could have been better, significantly better.
Doesn't the CPLR require it to be better? It said that you have to put not only the dates that you attempted service, but also the time of day, so it can be evaluated as to, you're not showing up at 3 in the morning or every day at work hour, something like that.
It does, Your Honor, and all I can say here is that there is one time listed for the last time that service was attempted. I would just argue that under the circumstances of this case, that should be deemed sufficient. If it's not, there is no, obviously there can't be a default judge. If service is improper on those 3 individuals, then obviously we would not be entitled to a default judgment as to those.
I don't know what the basis for reversing Judge Chaffee on saying that the service is to those defendants. I mean, as to Huggins, you show good service. As to the provided defendants, you show good service. But as to those defendants that she's found that you did not, your affidavit of service is inadequate, I don't know where there's a basis to reverse. I mean, that's what the statute requires, and
I understand, Your Honor. The only, again, all I can say on that is they do list the times. Not the times. The 3 dates, 3 specific different dates, and the last one has the time, the last date on each person. Clearly, I can't say that their times are there for the first 2 attempted services. They're not, and I can't come before this court and say anything other than that. I would just ask, under these circumstances where these parties haven't shown any inclination to respond to anything, the affidavit of service on its face with 1 time out of 3 is sufficient. If it's not, we're not entitled to a default judgment on those.
I mean, there isn't a case which says that 1 out of 3 is enough.
There is not. I will only say that there are cases that say each case is whether due diligence was done is evaluated on a case-by-case basis. And I would ask that on this case the court find that due diligence was done. If not, we still have the defaults for all the medical providers and Mr. Huggins. If there are no further questions, I would rest on my brief.
Thank you, Mr. Bodoff. We appreciate your coming in to speak to us, or showing up to speak to us.
Thank you very much, Your Honor. Have a great day.
Thank you very much. You too. Okay, the next case for oral argument is Perez versus Long Island Concrete. We'll hear from counsel for Long Island Concrete first, Mr. Ratner. Is that correct?
Yes, Your Honor. Thank you. And may it please the court. On this appeal, the Long Island Concrete defendants are here requesting 2 primary forms of relief. First, we want the decision and order of the lower court to be reversed and all the breach of contract claims against Long Island Concrete to be dismissed for various reasons that we set out in our appellate briefing. Second, we ask respectfully that the court hold that all plaintiffs' claims prior to September 17th, 2014 are time barred due to the drastic amendment of the complaint. Now, we've extensively briefed the reasons why the breach of contract claim should be dismissed, but I'd like to touch on just a few points for the court today. If you look at the affidavits and documentary evidence that the plaintiffs submitted to supplement their pleadings, what your honors will find is that Perez and Frias did not work on the Park Avenue Armory Public Works contract, and they did not work on the FDNY Rescue 2 contract during the time that Perez, at least, was receiving paychecks from Long Island Concrete. Frias, of course, never received paychecks from Long Island Concrete. Why that's significant is because to hold Long Island Concrete liable for a breach of the public works contracts, there has to be a sufficiently immediate relationship between the laborer and Long Island Concrete. And here you don't have that. There's no argument that they were directly employed by Long Island Concrete, with one exception, which I'll
But
get.
weren't they also supervised by Long Island Concrete foreman? And wasn't their rate of pay set by the Long Island Concrete's COO?
No, they allege that they were supervised by Long Island Concrete foreman, but that alone is not enough to impute Long Island liability to Long Island Concrete, because their whole analysis depends.
Didn't they also get some checks from Long Island Concrete?
So this is what happened. Or according to the plaintiffs, they say that they received paychecks from Regulator, and then that two of them received paychecks from Long Island Concrete, and that was approximately 6 months, and then they started receiving paychecks from Regulator Construction again. That's what they say. But that doesn't mean that Long Island Concrete employed these plaintiffs when they were receiving Regulator paychecks. And
well, I mean, aren't these issues here? I mean, at this stage of the game, I mean, if you get a check from somebody and there are trucks there and they're supervising, maybe you'll be able to prove they weren't. But it seems to me those are issues of fact at this stage of the game.
Well, I think, Your Honor, we're not arguing that Perez and Ramirez were not Long Island Concrete employees for the period that they were receiving Long Island Concrete checks. That's not in dispute. What is in dispute is whether Long Island Concrete can be held liable for time periods when the plaintiffs were receiving Regulator checks. And to do that, they have to actually plead alter ego liability, and they haven't done it because they haven't actually alleged domination and control. And when you tick through the factors of what is required to allege alter ego liability, they haven't done it. There's no allegation about disregard of corporate formalities. There's no allegation about inadequate capitalization. In fact, the opposite is true, because they're arguing that they were paid from separate companies, separate bank accounts with separate checks. There's no allegation of intermingled funds. There's no overlap in ownership. Pernod is the owner of Long Island Concrete, and there's no allegation here that he owns Regulator or that any family member of his owns Regulator.
Weren't they? Didn't they work out of the same location, and didn't they share the same construction superintendent and use the same yard and have same employees handling the payrolls? I mean, there are overlaps here that are alleged. There
are allegations that speak to that. However, when you delve into the record, you'll also find that the plaintiffs allege that Long Island Concrete and Regulator had separate offices and had separate equipment. And for that, I'd refer you to record pages 208 and 218. The fact that—
Well, this is a motion to dismiss, isn't it, if I'm correct?
Yes, that's correct. However,
it's not a motion for summary judgment. Maybe on a summary judgment motion, things might be a little different. But on a motion to dismiss, we're supposed to give them the pleader every benefit of the doubt, right?
You are correct about that, Your Honor. And what I'd say in response is a couple of things. First, that you have an extensive record here, almost all of which was actually submitted to bolster the pleading. And so you can take what they both put in the record into account. And
well, if we're going to convert this to a motion for summary judgment and search the record and grant summary judgment, we have to advise the parties of that pursuant to the statute, I believe.
Okay, I was thinking that the question becomes whether the plaintiffs have a cause of action, and here, when you look at the record, they don't.
Well, I said to you, and you agreed with me about the standard on a motion to dismiss, and then you said there was all this other information that we could look at, which sounds to me like searching the record.
Well, Your Honor, the reason I said that is because the submissions here that are in the record are largely from the plaintiffs themselves, and they're meant to bolster the allegations in the complaint. But when you actually look at it, it doesn't, and it actually the opposite turns out to be true.
We don't have contracts for all the jobs, do we? For all the locations?
I'm sorry. Can you?
We don't have contracts for all of the locations.
No, and we're not moving to dismiss all the locations based on documentary evidence. We're moving to dismiss three of them.
So these public work contracts have project labor agreements, right?
Yes.
Are the plaintiffs bound by that?
Yes, they are, because what they're trying to do is they're trying to obtain direct benefits in the form of the prevailing wages.
They want the benefits without the liabilities that flow from that. But is the fact that they at least for pleading purposes, say we don't even know, we may not even have seen those project labor agreements, does that excuse them from the project labor agreements requirements?
No, it doesn't, and here's why. Because if you look, for example, at the 424 with project labor agreement, which is in the record beginning around, and I'm going to be rough on this, I think it's 579 to 630. If you actually look at it, it binds both union labor and non-union labor. So there's a series of escalating steps that ultimately can result in arbitration. But if you look at Section 6 of the project labor agreement itself, which is on page 596 of the record, it says that no employee shall be discriminated against at any program work site because of the employee's union membership or lack thereof. If you look at question 8 at the beginning of the project labor agreement, which is 567 to 568, that also makes it clear that the PLA applies to non-union labor. So if they had a grievance—
Can you wrap up, because we've given you a lot of extra time here? Thanks.
Yes, I appreciate that, Your Honor.
I know we've been asking questions. I understand that.
That's fair. So the nub of the argument is they have to allege some kind of employer relationship with Long Island Concrete. They haven't pled alter ego, and the project labor agreements bind them, and they cannot bring suit against the Long Island Concrete defendants for those 3 jobs. Thank you.
Okay. All right. We'll give you a little time to respond. Is the attorney for regulator here, Mr. Thomas?
Yes, I am, Your Honor. Can you hear me?
Yes, we can. Thank you.
Good afternoon. I will try to be as brief as I can. I, needless to say, agree with Mr. Ratner's arguments in full as regards the sufficiency of the pleading vis-a-vis alter ego, and would also point out that as against regulator, Judge Crane's decision appeared to be based exclusively—
What, if anything, is the fact? What, if anything, is the fact that both regulator and LIC are using Brent Walker as a concrete construction superintendent? The regulator truck is on the LIC job sites. Does that, for pleading purposes, does that get the plaintiffs to try to have the alter ego liability?
I would respectfully suggest that it does not, Your Honor. Does it amount to some degree of smoke? Perhaps, until one considers that there's hardly anything unusual on any given large job site about the presence of multiple contractors, even within a given area such as concrete and masonry. The fact that they shared exactly one supervisor at differing times, I would suggest establishes nothing.
How about the fact that the paychecks list the same telephone number for both companies?
That by itself, I would likewise suggest, is insufficient, given.
Okay, but now, again, bearing in mind this is a pleading motion, but that's not the only thing. You've got Bruce Walker, you've got their truck being present. Do you put this together? Does that get you past the pleading problem? Does it get the plaintiffs past the pleading problem?
Well, Your Honor, as we set forth, both Mr. Ratner in LIC's briefs and I in mine set forth at great length, this court has repeatedly held that, including that baby fat decision, among others, that, you've got to allege certain things that amount to, or at least indicate, complete domination and control, as well as shared ownership. There is not even a conclusory allegation of shared ownership. And as to domination and control, It's noteworthy that for whatever reason, Justice Crane left out the word complete when in her decision, she cited the Baby Fat Holdings decision. The point is, nothing about this complaint amounts to even conclusory allegations of complete domination and control. And again, there's nothing regarding joint ownership. I would like, if at all possible, however, to hasten in my limited time to the statute of limitations issue. The fact is that Justice Crane based the relation back as far as the pre-September 2014 claims against regulator are concerned, apparently on the idea that, well, if the corporate veil can be pierced, which may or may not be the same thing as alter ego, which was alleged by the plaintiffs, then therefore you have unity of interest for purposes of CPLR 203. And the minute you have unity of interest for CPLR 203, no further analysis is required. That is simply not the case. It's not the case whether you're characterizing this as veil piercing or alter ego. As it happens, plaintiffs did not allege veil piercing as such as their basis for holding regulator liable. They cited alter ego. Either way, to get the benefit of CPLR 203, this court has repeatedly held, and indeed the Court of Appeals held in the very decision that plaintiffs relied on here, that there has to be a mistake in the original omission of the subsequently named plaintiff. Now, the subsequently named defendant, which here, of course, is regulator. They sued us in September of 2020. Insofar as these are contract-based claims, obviously that would normally limit them to claims accruing on or after September of 14. However, Judge Crane held, essentially in keeping with plaintiff's argument, that they get a relation back to 6 years before the time they sued LIC. Thus, the claims extend back to 2012, even against regulator. The problem is that the omission of regulator from the original complaint was not a mistake. And I rather doubt that Mr. Mermelstein is going to contend otherwise. In any event, plaintiffs barely claimed otherwise in all their papers below. It was not a mistake. Indeed, if you look at the original complaint, which is in the record, I believe, starting at 228, at page 231, you see in the original complaint, right on the very first page, you see reference to defendant regulator. Now, that was a mistake, apparently, only insofar as they didn't then actually sue defendant regulator, even though they named them in the opening paragraph of the complaint.
Well,
that was
yeah,
it.
I know they disagree with you on your allegation as to that it wasn't intentional, it was a mistake. But
well, Your Honor, with all respect, they barely disagreed with us on that. I would suggest that next to nothing in the record amounts to a claim that it was a mistake. And indeed, if there is that, I would suggest with the utmost respect for counsel that that would be sanctionably frivolous, because they demonstrably knew of regulator as a potential defendant in this matter. How do we know that? Because they identified them in the original complaint.
Okay. Can you just finish up, because I've given you a little extra
Sure,
time.
Judge, that's really pretty much it. I mean, I just want to reiterate that this requirement of a mistake is clearly not satisfied. It is a bedrock requirement. It was not satisfied. So all other issues aside, the pre-September 2014 claims cannot relate back beyond that and should have been dismissed.
Okay.
Thank you.
Thank you. Thank you very much. Can I hear from Respondents Counsel, please? Mr. Mermelstein, you're on mute.
Can you hear me now?
Yes, we can.
Okay. So With regards to the first point about the stating a claim for breach of contract, Mr. Ratner said that no plaintiff worked in Park Avenue Armory, but it's right there in the complaint, in the second paragraph of the amended complaint. It alleges that they worked at all these sites. The complaint must be taken as true, and therefore, at this pleading stage, that pretty much ends the argument. To the extent that it's contradicted or it's omitted from other additional submissions that plaintiffs made.
Are the plaintiffs who worked on projects that are covered by public work contracts, which have public project labor agreements, are they bound by those project labor agreements?
They are not. And the reason, we cited several reasons, but I would say the primary reason is we're not suing on the project labor agreements. They are suing based on statutorily.
Yes, but those cases where you're suing based upon the contract, which has a project labor agreement, how are you able to sue under the contract but walk away from the PLA provision of it?
First of all, we are suing under one contract, and they are citing a provision in a separate contract. That contract has not been incorporated.
But they're tied together, aren't they?
But we're talking about a dispute resolution provision, which needs to be specifically referenced. It's not good enough, according to Matter of Alliance, simply to reference generally that the PLA is part of the contract. You have to say that the PLA's arbitration provision is part of this contract, and none of the references that appellants bring up do that, and they're therefore insufficient as a matter of law. Moreover, we're talking about a provision that's it reduces the statute of limitations from 6 years to 7 days. That is unconscionable by any measure. We have, there are other reasons why they wouldn't be bound as well. I mean, there's this court in in the ANSA case found that in a prevailing wage case, non-signatories were not bound. It's not clear why this court would want to change its mind on that issue either. There's, the Court of Appeals in Cox created a right for workers to pursue their claims in court, and the PLA's dispute resolution provision does not allow that. It allows the union to pursue it on behalf of a non-union worker. That's not much of a right at all. That's certainly not what the court had in mind in Cox when it said that administrative relief was insufficient. So no, they are not. They would not be bound by the PLAs for those and those many reasons. I just wanted to touch on the idea that somehow LIC is not the direct employer of plaintiffs. First of all, it's alleged directly in paragraph 8 of the amended complaint, but the test for that is an economic reality test. You look at the Carter factors. Did they have the power to hire and fire? 77 and 79 allege of the amended complaint allege that Pernod, the head of LIC, specifically fired one of the plaintiffs through a foreman, and that it alleges in 66 and through 74 of the amended complaint that Pernod and LIC foreman controlled their work schedules and work conditions. It alleges that Pernod personally authorized raises for the plaintiffs on 3 separate occasions, which demonstrates that LIC had control of their pay. Their checks were being distributed through LIC offices and foremen. Plaintiffs went to LIC's office whenever they had an issue with any of their paychecks, including their regulator paychecks. And LIC obviously maintained earning reports for at least 2 of the plaintiffs, because it's in their brief in 16 through 18 of their opening brief and in the record at 2281. But I also wanted to get to the domination and control issue. And one issue that's
what I was going to ask you. What did you allege that at least lets you make out a cause of action for that under complete
Well,
domination.
one thing I would start with is that the president of Regulator was simultaneously working as a foreman for LIC and directing plaintiffs' work in that capacity. So he was the president of Regulator was reporting to LIC's president. And that's in the
Was
supplemental
reporting
record.
to whom? I'm sorry, I missed that. The president of Regulator was reporting to whom?
The president of LIC, because he worked for LIC as a foreman, even though the president of LIC testified that LIC and Regulator are competitors and totally not related.
Did you explain why you did not initially assert these claims against Regulator, as Mr. Thomas argued? If you identified them and you knew about the interconnection, why would you not have asserted some of those claims in the initial complaint?
Some of these connections have only become clear on, upon discovery. Plaintiffs knew that their paycheck said Regulator, but they did not know that they had never met anybody who had identified themselves as being from Regulator. Even though the paycheck said Regulator, everybody they dealt with, LIC, the foreman, they were identified as LIC. The projects were LIC. The office administrators were LIC. The office was LIC's office. They didn't actually believe when we talked to them that Regulator was anything more than a name. It's only once we commenced litigation and we found that LIC was blaming everything on Regulator that we realized that they were a totally necessary party.
Okay, does anyone have any further questions? Because, okay, I gave the appellants 1 minute each to just respond on your most important point, which is about all 1 minute gives you. So, Mr. Ratner.
Thank you very much, Your Honor. Okay, couple of quick points. With respect to shared telephone numbers, allegedly shared personnel, and operations running out of the same office, I'd respectfully urge the court read carefully Butler versus Teachers Insurance and Annuity Association. That is 2020 New York Miscellaneous Lexus 10767. It's cited at page 38 and discussed extensively in our opening brief. There is those facts, even if true, don't establish alter ego liability. Next point, the interpretation that
Counsel, was that a motion to dismiss?
I don't know offhand. I don't know offhand.
That's a really important factor in our thinking about this.
Of course, and I don't know, honestly, I don't know the answer sitting here right this second off the top of my head. But if it's not enough to prove an alter ego, then if the allegations track what is in Butler, then they haven't actually alleged an alter ego claim. So Butler is persuasive for that point. Next point, the idea that plaintiffs are not bound by the arbitration provisions in the project labor agreements it doesn't make any sense, because if what they're saying is that taken to its logical conclusion, what they're saying is any union member who may not know about the project labor agreement itself would not have to follow the dispute resolution mechanisms. In essence, anyone who doesn't know about the project labor agreement is not bound by it. That leads to the absurd result of the project labor agreement not being enforceable and not being applicable in terms of dispute resolution. So that takes care of that. Regarding ANSA, the first department case that was raised, the issue in ANSA was different than the issue here. The issue here is not a question of whether, for the sake of argument, plaintiffs are entitled to be paid prevailing wages. That was the issue in ANSA. The issue is whether the plaintiffs are bound to the grievance procedures in the PLA. And another important distinction in ANSA is that in that case, there had been litigation about whether the plaintiffs had exhausted their administrative remedies, and the provision at issue that would require arbitration was discretionary, and it was invoked by the contractor only after significant litigation had occurred, only in the context of summary judgment. Here, we're not arguing that they failed to exhaust their administrative remedies. We're saying from the outset of this case, they didn't follow the PLAs. It's an entirely different situation.
Okay,
And what about the fact that the president of regulator reported to the president of LIC, for which he was a foreman, in terms of?
Right. So the way this works is Serge Joseph, who's the president of regulator, has his own company. And in construction, when jobs finish, people get laid off. They're looking for work. Foremen come and go. It's not necessarily a stable workforce like in a law firm. So the fact that that Mr. Joseph actually had his own company and hired or paid certain of these plaintiffs, that doesn't mean that he was under Pernod's direction and control.
But the complaint does allege that, about the fact of the president of regulator reporting to the president of L.
I don't think the complaint alleges it in those words. So no, I can't agree to that. I don't agree to that.
okay, Mr. Thomas, you have a minute to just respond. Oops, you're on mute. Sorry, that's a standard problem these days.
My apologies. The
No
complaint absolutely does not allege, as far as I recall, that the owner of regulator reported to Mr. Pernod as such. Obviously, an allegation like that would certainly, tend in the direction of complete domination or control. The fact is, I don't believe the complaint does allege that, and I think the complaint is otherwise devoid of the requisite allegations in that regard. The only thing I would return to, in let's hope it's 30 seconds or less, is any suggestion that plaintiffs previously claimed that the omission of regulator from the original action was some sort of mistake. I understand what Mr. Mermelstein just said, except that, again, it doesn't really get him past the graphic record evidence as reflected in the original complaint itself. Much more to the point, they did not claim to Justice Crane, nor did she find that they had made a mistake in originally omitting regulator, nor do they claim anything of the type in their brief on this appeal. So there's nothing in the record to support any suggestion, nor did they in fact argue at any point that regulator's omission previously was a mistake. Therefore, there's no relation back. Thank you.
Okay, well, you've given us a lot to think about, so thank you all very much and have a great rest of the day.
Thank you, Your Honor.
Thank you, Your Honors.
Thank you.
And our last case for argument this afternoon is People versus Dash. So if we can hear from counsel for the appellant first. Good afternoon, Ms. Knight.
Good afternoon, Margaret Knight from the Office of the Appellate Defender on behalf of Damon Ash. Mr. Ash's assault conviction must be reversed because the court's refusal to charge justification deprived Mr. Ash of a complete defense to the assault charges. Where the prosecution's case relied almost entirely on the—
Well, let me, I thought you made a good point. I thought about this issue of justification a lot, but really the issue about the knife and whether there ever was a knife when nobody ever saw a knife and may have just heard some references to, was that enough to bring justification into this trial where the whole trial would have turned upon whether there was a knife that nobody ever saw or found?
Absolutely, Your Honor. And I would direct the court to the security guard's 911 call that was admitted for its truth as a present sense impression. And it was detailed. It was not just speculative. I mean, it was admitted as a present sense impression because he was watching it, and it was hurry, hurry, hurry. They're fighting. They're cutting each other. And when the operator asked what the emergency was, the security guard said, they're cutting each other and fighting with a blade and a bottle. They're bleeding all over the place. And then when EMS asked, what had happened, who was stabbed, he said both of them, one in the face, one in the elbows. And that's consistent with the injuries that Mr. Ash indeed suffered. He had a laceration that looked like a slice wound to his face, and he had another laceration to his elbow. So he also had injuries consistent with that. And I just repeat again that this is to view the evidence in the light most favorable to the defense. This was a chaotic scene. It went on for about 10 minutes. Both of them had their apartments right there next to it. So there was ample opportunity to dispose of the knife during that period of time. And it's really whether or not there's a reasonable view of the evidence. And there's a reasonable inference that either one of them was the one to first pull out a weapon in this case. We know from, again, most reasonable view of the evidence that the security guard says they're fighting with the bottle.
What is the evidence that the defendant himself saw a knife or knew that the defendant had a knife during the altercation? Where's the evidence of that?
The injuries he sustained would be, I think, the most obvious one, that he had injuries that were consistent with being sliced with a knife, and the security guard saying they're fighting with that, and they're both stabbing, that they're stabbed. So really, again, there's a reasonable inference.
Isn't it a problem for you in this case that the defendant was the initial aggressor, and there doesn't seem to be any testimony other than that? Wouldn't that negate your request for this justification charge?
Absolutely not. That was a fact issue. And actually, the only evidence that Mr. Ash was the initial aggressor was Mr. Mendez's account. Mr. Schechter, who overheard things, said that Mr. Ash certainly started the verbal portion of the events, that he was.
Why did Mr. Schechter see?
Mr. Schechter didn't see anything. He was an ear witness, but he overheard Mr. Ash banging on the door. And like defense counsel acknowledged at the very beginning and opening, Mr. Ash was loud, but this was before a physical fight had started. He was saying that Mr. Mendez had stolen his marijuana and called him a punk and said he'd kick his ass. And what Mr. Schechter said is, like, about a minute later, Mr. Mendez came out and said, "Let's go." And that's Mr. Schechter's testimony of what he overheard. Now, Mr. Mendez said that Mr. Ash assaulted him, but Mr. Mendez was impeached with his own prior sworn testimony at the housing court proceeding that he couldn't say who was the initial aggressor, that they both came at each other. He was also impeached again by the security guard because he said he was unarmed. And if you credit the security guard's 911 call, he was not. And he was also impeached with his own liberty interest in this case. These are witnesses who didn't see anything. Schechter overheard events. So he said that he heard Mr. Mendez leave his room, say, "Let's go." Then he heard the fist fight. And then a few minutes later, he heard the security guard say, "Drop the knife." So really, there is no credible evidence that Mr. Ash was the first one to use a weapon, or that Mr. Mendez. We would suggest actually that the more reasonable inference is that Mr. Mendez was the first one, because he admitted that he had a knife in his room. He comes out of the room and says, "Let's go." Mr. Ash was not accused of hitting with the bottle until they'd gone all the way across to the other side of the common room. And so it's absolutely as reasonable an inference that Mr. Mendez came out with that knife, that somehow he was able to get it during the course of the fight a few minutes later, before, after Mr. Ash got to the bottle. I mean, that's just as speculative. And really, at the end of the day, our point is that it's equally reasonable that either one was the initial aggressor. This is absolutely a question of fact that should go to the jury, and that would undermine the burden of proof. This is not speculative. It's not irrational. We're not asking the jury to come to a far-fetched conclusion. It's really a simple issue of which one pulled out a dangerous instrument first. That's a fact question for the jury. And the Second Department case in People v. Singh is similar, not exactly on point, but I think is very instructive. And there, even though there was no counterfactual narrative, they pointed to the serious inconsistencies in the complainant's account. There was a 911 call there that they were both fighting with knives. And actually, Mr. Ash's case is even stronger, because there the 911 call was fairly vague. Here, it's a call over 10 minutes where the security guard is crystal clear that he's seeing them fight, both fighting with weapons. And saying the complainant did not suffer injuries that were consistent with being injured with a knife or a blade, whereas Mr. Ash, in fact, was. So where a reasonable jury could infer that either one was the first one to pull out a dangerous instrument, that's a fact question that should go to the jury, and the denial of the request deprived Mr. Ash of his right to a full and fair defense.
All right, thank you, Ms. Knight. You'll have 2 minutes for rebuttal. We'll now hear from Ms. Wiseman. And before you get, Ms. Wiseman, before you go into the discussion about justification, which I'm sure you will, of course, I just want to confirm that you agree that we need to dismiss the conviction of coercion in the first degree for the reasons that were in the briefs, correct?
Yes, Your Honor. I mean, I think it could be reduced to attempted coercion, but it's essentially irrelevant because it's a concurrent sentence. So yes, that should not have been submitted to the jury.
Okay, that was just seems to be an oversight by everybody, I guess. All right, so if you want to go on to the justification issue and whatever else, thank you.
Thank you, Your Honor. May it please the court, my name is Alice Wiseman. I'm appearing on behalf of the people. The judge here correctly determined that there was no evidence before the jury from which it could have determined, without engaging in rank speculation, that the defendant only resorted to deadly physical force in response to a threat of imminent deadly physical force from Mr. Mendez. And that's crucial because, both a subjective and objective component, because even leaving aside, and the court can listen to the security guard's account, he was very agitated. It's not at all clear that he's describing something that he's seeing or what he's seen or what he's inferring. But even if, despite the fact that no knife was ever recovered and that the defendant, that the imbalance in the injuries here is pretty substantial. The complainant has substantial injuries that are consistent with being hit by a bottle, and a lot of other injuries too that are consistent with his account that he was the victim of the attack. But as I say, even if there had been a knife at that point when the security guard came along, that says nothing about when the knife came out and when the blow with the bottle was struck. At the point the security guard arrives, certainly Mr. Mendez is already gushing. There's blood all over the place, as he repeatedly emphasizes, and that blood is coming from Mr. Mendez. So there is literally nothing other than speculation that would lead the jury to say, well, this happened because after the defendant had instituted this by pounding on the door and threatening to kick his ass, Mendez pulled out a knife. And I think it's instructive. There are things that could have come in that the defendant could have testified. But on the evidence is actually before the jury, there just isn't anything. So even though we could speculate that might happen, that's all the jury could have done. And I would note the Court of Appeals in People v. Watts, there's a case where there was actually evidence that the defendant had made a statement to the police. He said, he came at me with a knife. And there the Court of Appeals said, that's not enough, because from that statement alone, you don't know enough. You can't determine whether he had a reasonable fear of imminent physical injury. And of course, we don't even have that here. I think Singh actually is indeed an instructive case, but what's instructive is it shows how much more there was in Singh that justified a charge than here. Singh, as the majority of the Second Department emphasized, it was unquestioned. I think the complainant himself testified he started things by punching the man in the face and the defendant on the face and had him down on the ground and was punching him. There was a huge disparity in size and strength. I think the defendant was 5 inches taller and over 65 pounds heavier. He was extremely drunk. I'm sorry, the victim, I'm referring to the victim, was the one who was bigger, taller, drunk. He started it. He caused severe injuries to the defendant. The defendant told the police that he had been assaulted. The 911 caller said he had been assaulted. The victim's or the complaining witness's testimony regarding what had happened to him, he said he had a meat cleaver struck in his head, and that was not just not supported by the medical testimony, but was completely inconsistent with the medical testimony. So what the Second Department majority found there was that what necessitated charge was there were facts here that said this smaller man was being pounded on by a bigger man. those are circumstances that objectively it's reasonable under all these circumstances to think you might have a reasonable fear of imminent use of deadly physical force, not from a weapon, but simply from the power and the attack of a man who I think later, after actually knocked the defendant out with a single blow, I believe. So we don't have any of that here. We have men as seemingly more or less equal in size from their pictures. We have the defendant starting this, as confirmed by the only witness who testified and corroborated, I think, by everything that the ear witness, Mr. Schechter, heard. We have a struggle that consistent with Mendez's injuries to his back and the abrasions and lacerations. He said he was dragged by the defendant back to his room. That's all consistent. We have injuries consistent with the bottle. We have the shattered bottle in or at the threshold of the defendant's room. And just, basically nothing beyond speculation to say that somehow Mendez decided to whip out a knife and that he wouldn't have been justified in doing this, even if he had to defend himself. But again, there's simply nothing that he did. So for these reasons, I think the judge's decision was fully justified. If there are no other questions from the court, we'll rest on our brief. Thank you.
Thank you very much, Ms. Wiseman. Ms. Knight, you have 2 minutes to respond. Oops, you're on mute. Okay.
Sorry about that. Many of the arguments the respondent is raising here are, again, factual matters that should have gone to the jury, certainly, but don't undermine that the court needs to look at this in the light most favorable to the defense. Sure, the security guard was agitated, but he said they're fighting each other with a blade and a bottle. I mean, he was very specific as to what they were fighting each other with, and that's actually consistent with the evidence. Mendez did not have a slicing wound. The doctor testified to that, and the pictures of Mr. Ash suggest that he did. We've already addressed.
Well, but was there any place in the medical records where it was they specifically said that they were knife type of injuries as opposed to anything else?
Mr. Ash's medical records were not introduced. It was just photographs of his injuries where you can see the slicing injuries that even respondent.
How can you tell from a photograph if it was caused by a piece of a bottle or a knife?
We can't say for certain, but it's consistent with a knife. There was much more detailed testimony, obviously, about Mr. Mendez's injuries.
Is it consistent with the bottle? Is it consistent with the bottle?
Possibly. They are maybe an inch or 2 inch slicing wounds to his face and to his elbow.
So it's consistent with something sharp.
It is consistent with a sharp object, but again, all of these are factual issues that should go to the jury. Mr. Ash could have testified, but there's no requirement that he did testify. And again, we would definitely disagree with the import of saying there. The Second Department said one reasonable inference was that the fists were deadly instruments, but it didn't say, or was deadly physical force, but it didn't say that was the only inference. And it actually went at length about the testimony and the evidence in the case and what the 911 caller said and what the injuries were. And there, the complainant, although was not struck in the head probably with a meat cleaver as he testified, certainly was struck in the head with a knife, and there were staples to his head, just like here. And there, the defendant did not have any injuries consistent with being hit by that kind of instrument. And the Second Department pointed to the fact that there was a lot of inconsistencies and a lot of uncertainty about what weapons were used, when and how, and found that it was error to simply rotely rely on the complainant's account given all its problems. Here, there are a lot of problems with the complainant's account, and given that the burden of proof remains on the prosecution throughout, if it's not irrational or speculative, then the defense should go to the jury. And it's simply not irrational to conclude that a man who admitted that he had a knife in his room went out of his room with, I'm sure some legitimate grievances against Mr. Ash, but came out of his room saying, "Let's go," and a security guard minutes later is saying he's fighting with a knife, that he took that knife out of his room and started the fight with it. And that's something the jury should have been able to assess.
Okay, I think we got both of your points on this, and thank you very much. We will take a further look. Thank you all, although probably nobody else is still here anymore for appearing today except us. So thank you for being here, and this will conclude oral arguments for today, and court is adjourned. Have a lovely evening. Be safe.
You too.
Bye.